Let's prepare to begin. Yes. No, I'm doing it.
Madam President, before we begin, I asked if anybody needed an interpreter. Would you like me to ask again?
Yes, let me introduce you. Okay, just 1 second. And you can even use this mic if you'd like. All righty. Good morning. My name is Felicia Orth, hearing officer appointed by the Water Quality Control Commission to conduct a hearing in the matter of proposed new rule 20.6.8, the New Mexico Administrative Code. This is ground and surface water protection, supplemental requirements for water reuse, docketed by the Commission Administrator, WQCC 23-84R. We have a number of things to do this morning, but before I go into that, I'm going to introduce Lisa O'Grady. She is our interpreter between Spanish and English. Ms. O'Grady, would you please make your announcement from here?
Good morning. If there's anyone present in the hearing room that would like in Spanish interpreter services, please come forward and I will provide you with the equipment. Buenos días. Si hay alguien aquí presente que requiere servicios de interpretación, por favor, pase adelante y les paso los audífonos. For anybody who is online that requires interpreter services, there's a globe at the bottom left hand of your screen. You will need to click on the globe and choose Spanish. If you want to hear the interpretation from Spanish into English, then you will need to click on the globe and choose English. Si hay alguien que está compareciendo desde el internet por Webex, entonces por favor, para escoger su canal, al pie de su pantalla, de la pantalla, la mano izquierda, hay un globo. Por favor, seleccione el globo y luego puede seleccionar español. Si quiere escuchar la interpretación de español al inglés, por favor, seleccione el globo y luego puede seleccionar inglés. Thank you. Gracias.
Thank you very much. In addition to having interpretation between English and Spanish, we have a court reporter, Teresa Dubois, with us to make a transcript of the hearing. This is a resumption of a hearing we began on May 13th, continued through May 17th. First, let me say, as to the public comment expected, that we have 2 public comment sessions today. One is at 1 p.m. So we'll take a lunch break at noon, come back for the 1 p.m. public comment period. The second one is at 5 p.m. Every subsequent day this week in which we conduct the hearing, again, there will be public comment opportunities, but those opportunities will be at 9 a.m. and 1 p.m. So let me ask for appearances. Would the department like to start? I know you're not mic'd, but if you stand up and speak loudly, we can hear you. Great, thank you. Ms. Fox? Thank you. Ms. Nanasi? Okay. Do we have Mr. Davis? Thank you. And Ms. Taylor? Okay, thank you. And Mr. Wexler? Thank you very much. Yes. Okay, thank you very much for that reminder. Let's see, do we have Ms. Evans or Mr. Cox? No?
Honor, Colin Cox for the Center for Biological Diversity.
Okay, thank you, Mr. Cox. I can see you online. Let's see, Mr. Maxwell, I think I see you online.
Nicholas Maxwell appearing for the record today.
Thank you very much. And then we have Mr. So, Mr. Sage, Mr. Atencio. Are any of you on the platform? Okay. And Mr. Hightower. All right. Oh, there you are. Thank you. All right. Thank you all very much. Again, we have a number of things to do today. Now having had the appearances and knowing when the public comment period will begin, we're going to turn to Commissioner McWilliams. In the event, Commissioner McWilliams, you have a statement around the motions for disqualification. We did get several documents, including one this weekend from NMOGA, responding to the motion. All those documents are in the record, but if you'd like to make a statement, this would be your opportunity.
Yes, thank you very much. I'd like the opportunity to address these baseless allegations and clarify a few issues. Upon my appointment to the WQCC, I filed an initial financial disclosure. My financial situation has not changed since my initial filing, and no further disclosures have been required. My husband and I are part owners of an oil and gas company in the San Juan Basin. We use recycled produced water exclusively within our oil and gas operations and have no need to use produced water outside the industry. Therefore, there will be no financial benefit from these rules. I have not worked for ConocoPhillips in more than 8 years and have never been a part of the New Mexico Produced Water Consortium. Neither myself or my husband, nor Logos Energy or any subsidiary is a member of NMOGA and hasn't been since 2021. I am a member of IPANM board, but was not on the executive committee when hiring of Montgomery and Andrews and Mr. Wexler for any legal services to IPNM was secured, and have had no involvement in obtaining legal services for IPANM. Additionally, IPNM is not a party to the hearing, and I've had no ex parte communications regarding this hearing. Montgomery and Andrews does not represent Logos and hasn't for several years. 6 years ago, I filmed an educational video which aimed to inform the public about fracking. I did this on a voluntary basis and was not aware that the video continues to be used. This video has no relationship to the proposed rules, or this hearing. Finally, Logos is not a permit holder or an applicant for a permit under the Water Quality Act, which is governed by this commission. I believe that my background as an engineer in the oil and gas industry is one of the reasons I was appointed to the WQCC. My expertise allows me to offer valuable insights on rules affecting the oil and gas industry, helping to ensure that the commission makes informed decisions. Despite my industry background, I remain committed to the Water Quality Act's objectives of protecting public health and enhancing water quality. My obligation is to serve the public interest, not personal or corporate gain. As such, there is no reason for me to recuse myself from the hearing. If the commission would allow, I intend to remain a participant in the hearing and remain committed to serve New Mexico. However, I do not want to stand in the way of due process. In order to allow science to have its day in court, I will abstain from the final vote while providing my fellow commissioners my perspective for their consideration. Thank you.
All right, thank you, Commissioner McWilliams. I understand there might be some feeling that as a non-dispositive motion, it might be a motion I could or would rule on. I'm deferring that ruling to the commission as a whole. I understand the commission has counsel from the New Mexico Attorney General's office. I also understand that there may be another forum in which this question is explored. I don't think, however, that anything I might say on the basis of these pleadings would be particularly helpful. So the commission can take this up at a properly noticed meeting sometime before they deliberate. But that's all we're going to do on that motion this morning. Thank you. Let's see. Ms. Fox, you asked about your motion to exclude some of NMOGA's witnesses, exhibits.
Madam Hearing Officer, we have a new commissioner. Could we introduce
Yes, thank you.
Mr. Bailey?
Commissioner Bayless, if you would please introduce yourself.
I'm here on behalf of Toby Velasquez, New Mexico Parks Director. I work for him.
Hold that closer to.
Quickly on my background. I have 2 engineering degrees. My master's thesis had to do with nutrient kinetics in a receiving stream. Worked 16 years for the Alaska Department of Environmental Conservation. I was the chief of water quality for the state. I also worked on the Exxon Valdez cleanup. I've had 5 years with OCD early in the 2000s and in the teens. I also took some time off to work overseas. I worked in construction operations and design of LNG plants. I've lived in Peru, London, Perth, Tokyo, and Houston. So there were highs and lows. I've been working for state parks now for 3 years. I do the design and help with the operations of the water and sewage treatment plants at our 35 parks. And I'm an operator.
Thank you very much, Commissioner Bayless. Let's see, Ms. Fox. I had been agreeable to taking up this motion when you asked in the email last week. I'm wondering, though, if it would be better taken up when NMOGA actually offers its exhibits and perhaps offers them without foundation, for example. And we could take it up then. Come to a microphone.
Madam Hearing Officer, whatever your pleasure. On the one hand, I'm prepared to argue it today, and I do think it's right today, but whatever your pleasure.
I think I'd prefer to do it later, notwithstanding my email response there. All right.
Thank you.
All righty. So I believe at this point, though, we turn to your witness. Yes, Ms. Fox? All right. Under the commission rules, all testimony is taken under oath and is subject to cross-examination. So Mr. DeSalen, if you would please come to the witness table. That's all right. Okay.
Where's Pam? There you are. I'm going to need to screen share in just a bit.
Yes, I believe Ms. Jones will help you with.
Onto the WebEx. Should we take a few minutes while I do that?
All right. Yes.
Madam Hearing Officer,
Commissioner Brankard.
I think we discussed this at the end of the last meeting. Is there an order for the testimony?
Yes, sir. We do always make allowances for witnesses with time constraints, but we have been generally going through the petitioner and then those generally supportive of the petitioner, and then move along the spectrum to those not as supportive of the petition. So we hear from Ms. Fox and Mr. DeSala now. Then we move to new energy economy. Then there are some parties who are here supportively without witnesses. And as we move along, we move toward Mr. Maxwell and Namoga. We'll presumably finish up with Namoga. And there's always a possibility of rebuttal and surrebuttal and all of that, but folks, parties have been including that in their testimony.
Have we heard from Wild Earth Guardian?
Yes.
They testify.
Hold on. Mr. Davis? Okay. Commissioner Brankard wanted to know if we'd heard from a witness for you. You have to come to a microphone.
Hello,
Yes.
it's on now. Pardon me, Tim Davis, Wild Earth Guardians. Guardians does have one witness in this matter, Melissa Troutman. I sent around an email last night to the parties seeking their positions on potentially stipulating that Miss Troutman's testimony be entered into the record for the reason that she is recovering from an unexpected surgery. I do not know when she may be available to testify. There was one objection as of last night to doing so, and I believe that her availability will be a moving target. And so I really have no further information that I can give the commission at this time. I'm hoping that we can all reach some sort of a resolution on when we could potentially make her available in the future, and would request that that is done remotely. I don't want to bring everyone back into the hearing room in person if it's not necessary.
Thank you, Mr. Davis. Other questions, Commissioner Brankert?
Actually, yes. In your procedural orders, have you placed any limitations on the parties filing additional amendments to the rule proposal?
Yes, I believe there was a deadline for that. I believe it was the same deadline as filing an NOI. If you have an amendment to the rule you wanted to file, I thought that needed to be explained in the NOI. Is that not true?
Madam Hearing Officer, Commissioner Brankard, we could file amended proposed rules with the rebuttal NOI on the one hand, but on the other hand, the practice has been that you can file additional proposed rules throughout the hearing process, depending upon the evidence.
In fact, we had that discussion at a pre-hearing conference. As the evidence comes in, sometimes the parties move, thankfully, toward one another on what they are willing to accept in a final rule.
Madam Chair, I realize I'm slow, but it's sort of difficult to keep up with what everybody's current positions are because they keep filing more amendments to their positions. I would assume that when we're done with the testimony, the parties will be allowed to file a final proposed amendments.
Yes, the parties understand that they're being asked to put closing arguments in writing, not to offer them verbally at the end of the hearing, and to also offer whatever final version of the rule they believe the commission should adopt.
I guess I just hope the parties will sort of stop filing amendments and wait till they get to do that after the testimony's over. It's a bit of a moving target here with all the parties and all the different proposals.
I think they're just trying to be forthcoming, Commissioner Brankert. But all right,
Thank you.
thank you. Ms. Fox, are you on the WebEx?
Thank you, Madam Hearing Officer, Commissioners.
Hold on one, I'm sorry.
Oh.
I just wanted to confirm you were on
Oh.
the WebEx and now I can see it
Yes.
on the screen. So first I have to swear in the interpreters, Ms. O'Grady and your team member whose name is?
I'm Lisa O'Grady. I'm handling the technical aspect. My interpreters online are Amelia Cardena and Betty Zeman. Ladies, if you can please go on the English channel to take the oath.
Okay, thank you. Do you and each of you swear or affirm that you will interpret faithfully between English and Spanish and English for this record? Thank you.
Betty?
Thank you very much. And now, Mr. DeSalen, do you swear or affirm that you will tell the truth? Thank you very much. And I'll ask you to spell your first and last name for the transcript. Thank you. Go ahead, Ms. Fox.
Thank you, Madam Hearing Officer. Mr. DeSalen, what is your current employment?
Yes, I'm an environmental lawyer, and I currently work for Coalition for Clean Affordable Energy. But I want to emphasize that today I am not testifying on behalf of Coalition for Clean Affordable Energy. I'm testifying only on behalf of Amigos Bravos and the Sierra Club.
What is your educational background?
I have a Bachelor of Arts degree in political science from Boston University College of Liberal Arts. And I have a Juris Doctor from Boston University School of Law and an LLM, which is a Master of Law from Katholieke University in Leuven, Belgium.
Would you briefly describe your work background?
Yes, I'm practicing environmental law for approximately 40 years. After law school, I worked for the Massachusetts Executive Office of Environmental Affairs in Boston. Next, I worked for the U.S. Environmental Protection Agency in the Office of Enforcement and the U.S. Department of Justice Environmental Enforcement Section in Washington, D.C. In 1993, I moved to New Mexico and worked for a series of state government jobs over a period of about 25 years. I worked first in the Office of the Attorney General in the Environment Division. I then worked for the Environment Department for about 14 years in the Office of General Counsel. And finally, I worked at the Interstate Stream Commission. Since leaving state government, I've worked now for two nonprofit organizations. The first one was the New Mexico Environmental Law Center, and the second one, as I mentioned, the Coalition for Clean Affordable Energy.
Has your work included drafting laws and regulations?
Yes, it has. I've worked on drafting regulations and statutes, legislation throughout my legal career, and I can quickly mention a few of them. So while I was at the Environmental Protection Agency, I helped to draft portions of the federal hazardous waste regulation. While at the Attorney General's office, I drafted amendments to the federal Superfund law. And then while I was at the Environment Department, I drafted regulations on state certification of federal permits, which this commission adopted. While working for nonprofits, I've worked on several regulatory rulemakings, the adoption of the methane waste rules before the Oil Conservation Commission, then the 2021 triennial review of surface water standards, which was before this commission, and then most recently, the Advanced Clean Cars 1, Advanced Clean Cars 2, Advanced Clean Trucks, and nitrogen oxides omnibus rules. And all of those were before the Environmental Improvement Board, as well as the Albuquerque-Bernalillo County Air Quality Control Board. I've also drafted at least half a dozen bills that have been introduced in the New Mexico legislature. I've testified before congressional committees on several occasions. I've testified before the New Mexico legislature, the New Mexico Mining Commission, and the New Mexico Oil Conservation Commission.
There was a suggestion during the Environment Department's testimony that the proponent of deleting unused definitions from the rule had never implemented a regulatory program. How do you respond?
Yes, I heard that testimony, and I sort of assumed that it was directed at me, and I have to disagree with those statements. I have implemented and enforced regulatory programs throughout my legal career over a period of over 40 years. So I can give you a few examples. While I was at EPA, I implemented and enforced the Federal Hazardous Waste Regulatory Program under the Resource Conservation and Recovery Act. I implemented and enforced the federal permitting program under the Clean Water Act and the federal drinking water program under the Safe Drinking Water Act. While at the New Mexico Attorney General's office, I helped establish and I represented the Natural Resource Damage Program in New Mexico. And that program is governed by regulations promulgated by the United States Department of the Interior and the National Oceanic and Atmospheric Administration, which is part of the Department of Commerce. Then when I was at the Environment Department, I helped to implement and enforce the State Hazardous Waste Program under the Hazardous Waste Act, the Groundwater Protection Program under the Water Quality Act, and the State Air Program under the New Mexico Air Quality Control Act. And these are all permitting programs. So I am very familiar with the implementation and enforcement of environmental permitting programs.
Is ABSC Exhibit 5 an accurate copy of your resume?
Yes, ABSC Exhibit 5 is my resume, and it is accurate and up to date.
Can you please outline the direct testimony you will give today?
Yes, and I want to begin by thanking the commission for allowing me the opportunity to appear before you and testify today. And I also want to thank the commission for your efforts in reviewing this rule and the rather voluminous record that supports it. So I'm going to discuss the department's proposed rule from a legal drafting point of view. And I have several recommendations to make this rule clearer, to make it more precise, and to make it more concise. And each of my recommendations is designed to make the rule better, to improve it, to make it more enforceable, and to make it more understandable. So I will briefly summarize my testimony. First, I will explain why some 23 definitions not used in the body of the proposed rule should be deleted. And these unused definitions are highlighted in yellow in, excuse me, in Amigos Bravos and the Sierra Club's red line of the rule, which is ABSC Exhibit 1. And I do not find the department's rationale for retaining these definitions to be persuasive. Second, I will respond to the New Mexico Oil and Gas Association's testimony on the reuse of wastewater for potable purposes. The department's proposed prohibition on potable application of produce water, as well as industrial wastewater and domestic wastewater, needs to be retained. Now, in the department's proposal, the prohibition is under Section 200, which applies to domestic wastewater. You can see on the heading of Section 200, it refers to domestic wastewater. Now, I recommend that this provision or this prohibition be moved to Section 100, which is the general prohibition. And again, as the department has written the prohibition, it applies to all three types of wastewater that are regulated under the proposed rule: domestic wastewater, industrial wastewater, and produce water. So the proposal, our proposal, would place the rule in a more appropriate location in general provisions of the rule. Third, I will discuss the deletion of unnecessary wording in the department's prohibition against discharge of treated produce water, and that's in Section 400A4. Fourth, I will discuss three proposals that Amigos Bravos and the Sierra Club are making to strengthen the notice of intent procedure for demonstration and industrial projects. That's under Section 400B of the proposed rule. The department has either adopted our three proposals, or at least has not objected to them. And finally, I will discuss Amigos Bravos and Sierra Club's objection to including industrial projects as an authorized use in the proposed rule. I'm not going to cover everything that's in my written testimony, only the most important points. And I also want to note that the Environment Department has accepted a few of our proposals, and we very much appreciate that.
Can you please identify ABSC Exhibit 6?
Yes. ABSC Exhibit 6 is my direct testimony, which was filed on April 15th, 2024.
Do you adopt it as your sworn testimony today?
Yes, I do.
Can you identify ABSC Exhibit 7?
Yes.
Exhibit 10?
Yes, ABSC Exhibit 10 is my rebuttal testimony, which was filed on May 6th, 2024.
Do you adopt it as your sworn testimony today?
Yes, I do.
Mr. DeSalen, I'm going to ask you a few questions about the sources you reviewed or consulted in preparing your testimony. First of all, are there any New Mexico rules that govern the drafting of state rules?
Yes, there are. The State Records Center has adopted rules governing the format and style of state rules. Essentially, these are rules on drafting rules. And these rules apply to this commission, and they're codified at section 1.24.10, New Mexico Administrative Code, or NMAC. The rules provide that style, quote, shall be guided by the Legislative Counsel Services publication entitled Legislative Drafting Manual. And the relevant portions of the latest edition of the Legislative Drafting Manual is ABSC Exhibit 7. And I want to say that I disagree with the statements of Ms. Fulham and Mr. Herman that the Legislative Drafting Manual applies only to drafting legislation. And that was in their rebuttal testimony. These rules expressly provide that the manual shall be used in drafting state rule. And that's at section 1.24.10.12a NMEC.
In addition to your own knowledge and expertise, did you consult any reference materials to prepare your testimony?
Yes, I consulted a number of references, drafting rules and legislation. My references are listed at the end of my direct testimony, my written direct testimony. And the guidance documents and references that I consulted comport with my own understanding of good rule and legislation drafting.
What documents did you review from this proceeding?
Yes, I read the notices of intent to file technical testimony and the rebuttal notices of intent from all of the parties. I read the direct and rebuttal testimony of all the parties. I read the department's proposed rule, the department's revisions to the proposed rule, and the revisions of the other parties. And I read many of the exhibits, although I did not read all of the exhibits that have been submitted. I also reviewed the public notice and the pre-hearing order.
What is the basis of your recommendation not to include unnecessary definitions in the proposed rule?
Good legal drafting should be clear and concise. It should not contain unnecessary words. A legal document certainly should not contain definitions of terms that are not used in that document. I think this should be obvious. And there are good reasons for this. It's not just because we've always done it this way. First of all, defining unused terms is simply unnecessary. It needlessly makes the rule longer and more complex. But if anything, we should be trying to make New Mexico's rules shorter and simpler. Second, definitions of unused terms lacks meaningful context. Having unused definitions makes it very difficult to follow the proposed rule, to grasp what the defined terms mean, and why they're even there in the first place. And it's very difficult to assess and analyze a proposed rule, or excuse me, a proposed definition to make sure that it's accurate and applicable and complete when you don't have any regulatory context for the definition. And this principle is especially true for technical terms, such as many of the definitions in this proposed rule. Without any regulatory context, this commission cannot consider the definition on an informed basis. Third, drafting unused terms makes the proposal very confusing. um, a, a reader might see a defined term that seems to be very important. So I can imagine, for example, a farmer that sees the term irrigation application. Then the farmer goes and looks at the rule to see how the term is actually used in the rule, but can't find it. So that farmer is likely to come away very puzzled and unclear as to how the rule is supposed to work. Fourth, defining unused terms suggests that the rule was carelessly drafted. Many readers will conclude that the unused definitions are a relic from earlier drafts of the proposed rule. They'll think that someone just simply forgot to delete the definitions as the rule evolved to the proposal. And this confusion is made worse in this proposed rule by the large number of definitions of unused terms. The proposed rule is relatively short. It covers only 6 pages, but it includes 52 defined terms. And of those 52 defined terms, 11 are not used in the proposed rule at all. And another 12 of the 52 defined terms are used only in other definitions. And that creates a needlessly complex and convoluted structure. The reader should not need to consult several different definitions to ascertain the meaning of one term. Now, several of these definitions are particularly confusing. For example, the proposed rule needlessly includes definitions of agricultural application, irrigation application, food crop application. The use of these definitions in the rule suggests that produce waters or other wastewaters could be land applied for agriculture or irrigation or for crop uses, food crop uses. But that's not the case. The rule actually says nothing about these possible applications of wastewater. And I want to point out that Ms. Tiffany Rivera of the New Mexico Farm and Livestock Bureau made very much these same points in her public comments. She recommended that the terms agricultural application, flood irrigation application, food crop application, and livestock application be omitted from the proposed rule, just as we have recommended. And I can give you a reference for that. That's in the volume 3 of the hearing transcripts at page 17. And then I have one final point that I want to make here. Ms. Fulham questioned my numbers in her rebuttal testimony. So as a rebuttal exhibit, I have prepared with some assistance a chart that lists each of the department's proposed definitions that are either not used in the proposed rule or used only in other definitions.
Madam Hearing Officer, may I approach to hand out exhibits?
Yes.
Mr. DeSalen, is that chart marked ABSC Exhibit 12?
Yes, it is.
Are you persuaded, that chart also, by the way, is in the Dropbox that is being used for this hearing? Are you persuaded by the Environment Department's rationale for defining these unused terms?
No, I'm not. The department's original rationale, as I understand it, was that the department would actually use these terms in future rulemaking. But that's not a satisfactory reason for including these definitions in today's proposed rulemaking. Although the Environment Department may intend to define these terms now for the future, that future may change. The future rules may be adopted in a form that is very different from what the Environment Department now anticipates. So the obvious answer here is simply to adopt the definitions as part of that future rulemaking. At that time, the terms will actually be used, and the context for these terms will be clear, and an informed analysis of the content will be possible. Now, in their written and direct rebuttal testimony, and in their oral testimony that was given in May, the department witnesses stated that the definitions will allow discharge permits to be referenced in a consistent manner. And they testified that the definitions will allow consistent oversight. But that rationale is equally unpersuasive. The department's testimony does not explain what problems these definitions will solve. There isn't any evidence that any of these terms are even in any existing discharge permits. And there's no evidence that any of these terms have been applied inconsistently in the past or have created any confusion. But there's another sort of more fundamental problem with the department's rationale. If this rule is adopted as the Environment Department has proposed, the scope of the definitions will not extend beyond the rule itself. So the proposed rule will not serve to define or redefine terms in existing discharge permits. Those permits are read within their four corners. So the definition would not have, or to me, these definitions, these unused definitions, would not have the effect that the department seems to intend. Now, if the department needs to define these terms for purposes of implementation and enforcement of its groundwater discharge permits, it needs to put the definitions in the permit. And all discharge permits contain a section right up front with all the definitions. Alternatively, the department could issue a guidance explaining how it intends to interpret and enforce the terms of the permit. But the department's justification for putting these unused definitions in the rule does not hold up to scrutiny.
Has the commission ever confronted a similar situation where the department has proposed definitions for terms not used in rule?
The commission confronted a very similar issue in the 2021 triennial review of surface water standards. The department had proposed definitions for two terms that were not used in the surface water rules. And Amigos Bravos, which was a party in that proceeding, objected to those two definitions. Amigos Bravos pointed out that these two terms were not used anywhere in the regulations and that they served no regulatory purpose. During deliberations, this commission agreed, and it voted unanimously against including these two definitions in the rule. And a copy of the relevant pages of the transcript from that commission proceeding or commission's deliberations is ABSC Exhibit 8. And in this case here, the unused definitions likewise should be deleted.
Mr. DeSalen, you recommend a new section 101 in the proposed rule. Could you explain why?
Yes. The proposed rule includes a prohibition on the department issuing a permit for potable application of reuse water. And that's in section 201 of the department's proposal. The definition of reuse water includes domestic wastewater, industrial wastewater, and produce water. So the prohibition applies to all three types of wastewater as covered on the proposed rule. But section 201, where this prohibition is currently written, is a provision that addresses only domestic wastewater, not produce water or industrial wastewater. So the prohibition is really rather misplaced. Accordingly, we recommend that the prohibition be placed in a new section 101, and that puts the prohibition more appropriately in a section of the rule that applies generally and covers all three types of wastewater. And this proposed change does not make any changes to the substance of the department's proposed rule. All it does is change the placement of this prohibition to a more appropriate section of the proposed rule.
Mr. DeSalen, it's section 400A4, which is the prohibition against discharge of treated produced water to groundwater. You recommend deleting certain language. Can you discuss your recommendation?
Yes. So I recommend deleting a passage from the last portion of section 400.A4 as unnecessary. So I would delete the words, and I'll quote, "without development and adoption of standards specific to treated produce water." And there's a parenthetical, subsection D of 20.6.8.400 NMEC, close paren, and then it goes on, "demonstration projects or industrial projects submitted to the department through the notice of intent process in subsection C of 20.6.8.400 NMEC are authorized to operate following the determination of no discharge permit required issued by the department." And that ends the quote. So all of that quoted wording there would come out. And the reason is that as proposed, section 400A4 would generally prohibit the department from issuing a groundwater discharge permit for treated produce water. But then the last phrase of this, the second sentence here, the first part that I read, would allow the department to issue a permit upon, quote, "the development and adoption of standards specific to treated produce water." This provision is problematic for a couple of reasons. Most importantly, it's totally speculative. It is possible that the department might at some point develop standards governing treated produce water, but no such standards have been developed or proposed or adopted at this point. So it really doesn't make sense to include that provision in there. This provision also references standards that don't exist. The provision consequently is likely to create confusion. And then, as I said, the provision is unnecessary. It's surplusage. It adds to the length and the complexity of the proposed rule, but it serves no regulatory purpose. And then the last sentence in the provision simply reaffirms that demonstration projects and industrial projects approved through the notice of intent process are authorized. That sentence is really redundant and unnecessary. Section 400B and section 400C are clear, they're specific, and they're detailed as to the requirements that demonstration and industrial projects must meet. I therefore recommend that the last part of section 400.A4 should be deleted.
Mr. DeSalen, can you please discuss the three proposals, the proposed amendments put forth by Amigos Bravos and Sierra Club?
Yes, there are three proposals that would amend the notice of intent provisions of the proposed rule, and that's in section 400. First, Amigos Bravos and Sierra Club recommend that the notice of intent for demonstration and industrial projects include information on the concentration of contaminants and on the quantity of the proposed, excuse me, on the quantity of the produced water that would be used. And this information is already required for notices of intent under the Commission's groundwater rules. And that's at section 20.6.2.2101 NMEC. Now, for consistency and for other reasons, we believe this information should be included in the produce water notice of intent application. And as Ms. Fulham testified, this information can be estimated prior to operations commencing. And the department has agreed to our proposal and adopted it in its rebuttal testimony. And that can be seen in NMED Exhibit 175 at proposed section 400.C1A. And we appreciate the Environment Department's making that addition. Second, we proposed a requirement that the department publish all applications for produce water notices of intent and related documents on its website. That is, and that's covered in my rebuttal testimony. The public has a keen interest in this, in the use of produce water, as evidenced by the extensive public participation in this rulemaking. Making this information available on the department's website is important to help keep the public informed. The department currently publishes applications for notice of intent for pilot projects for produce water on its produce water webpage. The department witnesses have testified that the department intends to continue this practice, and they have no objection to this proposal. The third thing that Amigos Bravos and the Sierra Club propose is results from the cross-examination of department's witnesses, in which they stated that an application for a notice of intent for a pilot program is currently required to give notice of the pilot project to adjacent landowners. So that requirement is reflected in two documents that are part of the record. The first document is attachment B to the 2022 Memorandum of Understanding before the New Mexico Environment Department and then New Mexico State University. And that MOU, including attachment B, is NMED Exhibit 55. Now, attachment B to the MOU requires consortium projects to provide a list of all landowners adjacent to the location of the proposed project. And it also requires a confirmation that the adjacent landowners have been notified of the proposed project. The second document is a consortium guidance document entitled, it's got a somewhat long title here, Guidance on Produce Treatment, Research, Development, and Demonstration, Testing, and Evaluation. And that's dated May 2022, and it's posted on the department's produce water webpage.
I'm showing you what's been marked ABSC Exhibit 13, which has been passed out to the commissioners and is on the Dropbox folder for this hearing. What is this?
This exhibit is excerpts from the guidance document that I just referenced. And on page 25 of the guidance, it provides that nearby landowners should be notified of a pilot project.
What did department witnesses say about adding a requirement in the proposed rule to notify adjacent landowners about demonstration in industrial projects?
The department's witnesses testified during cross-examination that they had no objection to this notification proposal. It is important for neighboring landowners to receive notice of these projects, so they have a better idea of what they're all about and what the potential health or environmental effects might be. So we propose that that the rule require an applicant submitting a notice of intent to notify the adjacent landowners of the project and to do so at the time that the application is submitted to the Environment Department.
I'm showing you what is marked ABSC Second Revised Exhibit 1, which is a red line strikeout of Amigos Bravos and Sierra Club's proposed amendments to NMED's proposed 20.6.8 NMAC, and Second Revised Exhibit 2, which is a clean version. These revised exhibits were placed in the Dropbox folder. Is Amigos Bravos and Sierra Club's proposal regarding notification to adjacent landowners reflected in these two exhibits?
Yes, it is. It can be found at section 400.C1A10. And that 10 is a lowercase Roman numeral, so it's a small x. In there, we propose a provision to require notice to adjacent landowners.
Finally, Mr. DeSalen, what is the basis of your recommendation to remove industrial projects as an authorized use in the proposed rule at section 400.B and C?
The department's proposed rule would include industrial project as an authorized use. In its direct testimony and exhibits, the department provided no evidence to support this proposal. Given the lack of evidence in my rebuttal testimony, I recommended that this provision be deleted. Now, in its rebuttal testimony and at the hearing, the department witnesses have submitted some testimony in support of this provision. But that testimony is really weak. I understand that industrial projects are prohibited from discharging to groundwater or surface waters under the proposed rule, but industrial projects would nevertheless pose a substantial risk to groundwater and surface water. And this risk derives from the accidents, the spills, and other releases of contaminants that would inevitably occur. And the department has not conducted any kind of quantitative risk assessment or any kind of analysis of those increased risks. And it has not analyzed the risk of a catastrophic accident. So because the risk of harm to groundwater and surface water from industrial projects is substantial, and because the department's evidence supporting industrial projects as part of this rule is quite insubstantial, I recommend removal of industrial projects as an authorized use.
Thank you for your summary, Mr. DeSalen. Sierra Club and Amigos Bravos move for admission of AB SC exhibits, second revised exhibit 1, second revised exhibit 2, and exhibits 5, 6, 7, 8, 10, 12, and 13.
Okay, thank you, Ms. Fox. Do I hear objections to the admission of those exhibits? Mr. Knight?
Madam Hearing Officer.
We need you in front of a microphone. There it is. There's a handheld in front of you.
Thank you. The department would object to the admission of Exhibit 13. It is misleading, and we have not had an opportunity to rebut it in our testimony.
Ms. Fox?
It's offered as proper serve rebuttal, Madam Hearing Officer. It was placed in the Dropbox last Wednesday. Glad to, just trying to limit the number of pages for the commission in this record. Glad to move to admit the entire document. I don't see, and Mr. Knight hasn't explained how it's misleading
Okay.
at
I'm
all.
sorry.
Mr. Knight,
I apologize. Exhibit 12 is what I was referring to.
the one,
Sorry.
table of definitions.
Yes.
Okay, what's misleading about it?
There are the excerpts are, just that. They're excerpts. It's incomplete. It does not provide proper context. And again, the real basis is that we haven't had the opportunity to address this in our testimony.
I'm sorry, I think you do mean exhibit 13. It's this one, right? It's excerpts from the guidance on produced water treatment, research, development, and demonstration, testing, and evaluation.
And again, I apologize for the confusion. It is exhibit 12 that we're objecting to, not 13. Yeah, it's the table that we're objecting to.
So it's defined terms in 20.6.8, proposed for deletion.
Madam Hearing Officer?
Hold on, I want to.
Yeah, and again, the basis of our objection is that it is misleading and lacks context, and we have not had the opportunity to respond to it in our testimony.
Okay, so my impression though was that it was based pretty closely, tracked pretty closely the testimony from Mr. DeSalen that was filed in April.
Yes, but I would ask that his testimony that was filed timely, that be what is considered by the commission rather than this exhibit. If they're the same thing, then they can just consider his testimony. I don't consider this this exhibit to add anything to that, and it I think it causes more confusion.
Great, thank you. Ms. Fox?
Madam Hearing Officer, this is offered in sur rebuttal to Ms. Fulham's testimony about the numbers of definitions that we're moving or recommending be deleted. It is proper sur rebuttal. There is nothing confusing about the exhibit, even if that were a proper objection. And if it is confusing, he has the opportunity for cross-examination right now of Mr. DeSalen on the exhibit, which was dropped in the Dropbox last Wednesday.
All right, thank you. So the objection is overruled. Exhibit 12 is admitted. Were there any other objections to the exhibits Ms. Fox enumerated for admission?
Your Honor, this is Mr. Maxwell. I do have an objection as well.
Alrighty. Go ahead.
My objection in part concurs with Counsel Knight's reasoning, and so I won't re-elaborate that as well. My understanding is the Dropbox was for large files and demonstrative exhibits. I did not receive any kind of service directly in my email of these exhibits. It's been 2 months since we recessed, and it's my belief that putting these as recently as they've been put on has now brought some shock value to this rulemaking, and for that reason, I object. Thank you.
All right, thank you, Mr. Maxwell. Your objection is noted. Perhaps we can take a moment, not now, but before lunch or after the public comment period, to identify anything else that might have been uploaded in the Dropbox folder. I would encourage all parties to look there. I was looking there this past week, certainly. Any other objections to be noted in connection with the proffered Amigos Bravos Sierra Club exhibits? No. All right, the exhibits you enumerated are admitted. Thank you, Ms. Fox.
Thank you, Madam Hearing Officer. May I just make one point, please?
Yes.
That is, there is no requirement for us to give notice of exhibits that we're going to offer for cross-examination or SIR rebuttal. There's never been that requirement in any of these proceedings. There is not that requirement in this proceeding. We did not have to put in the Dropbox those two exhibits last Wednesday, but we did.
Thank you very much. All right. I think before we launch into your questioning, Mr. DeSalen, that a break would be a good idea. And then we'll come back for the questions by commissioners and the other parties. It's 10:15. Let's break to 10:30. Let's come back from the break, please. All right. When we took the break, Mr. DeSalen had completed his direct testimony. We'll turn to commission questions and then to party questions. Commissioner Vihil, do you have questions of Mr. DeSalen?
Not at this time.
Okay, thank you. Commissioner Brankard?
Got so excited there. So, Mr. DeSalen, you were talking about these various definitions, particularly the application definitions that don't seem to have any purpose in there. My understanding in the Environment Department's testimony is that these terms could be used in discharge permits. Is it your position that they don't need to be in the rule to do that? They could just do that in a policy document, a guidance document?
My position is, first of all, that any terms that is defined for purposes of a permit need to be in a permit. Putting definitions in a rule that's issued or adopted after that permit has been issued are not going to have any effect on the permit. And my sort of secondary suggestion is that one way for the department to address this issue, if there is an issue, is by issuing some form of guidance document that explains how the department intends to implement and enforce the permits.
Thank you. Just to clarify your first point, isn't it true that the maximum term of a discharge permit is 5 years?
Yes, that is true.
And so after 5 years, each of those permits can come up for renewal and can be modified?
Yes, that's true. And I think I mentioned that in my written testimony.
So 5 years from now, all 95 of those existing discharge permits that have reuse water have been gone through renewal and could have these terms used in them?
Yes, and I presume that they've been issued over a staggered period, so they won't all come up for renewal on the same day.
Okay, so just quickly, you were opposed to NMOGA's proposal to eliminate bench scale projects, which by definition, I believe, is a project that occurs in a laboratory.
I think my opposition was removing it from the definition of a demonstration project And the key point there, Commissioner Brancard, members of the commission, is that we want a bench scale project to be considered a demonstration project so that it is covered by the notice of intent procedures that are in the rule. We don't want to allow sort of an exemption for bench scale projects.
Right. So it was with those procedures, it's just sort of curious. Your party is proposing to add to the notice of intent procedures notice to surrounding landowners. Is that correct?
That is correct.
So how would, one of Dr. Thompson's peers at UNM conducting a project at UNM give notice?
Well, I think that if we're talking about a bench scale project, the adjacent landowners requirement probably would not apply.
Okay, so you need to modify your proposal then to drop bench scale projects from that.
Yes, yes, I would agree with that, Commissioner Brancard.
Okay, thank you. That's it.
Thank you, Commissioner Bayless. Okay, Mr. Chair.
I don't really have a question, and I don't know if it's my point or not, but your definition, Exhibit 12, your definition of national pollutant elimination system should be national pollutant discharge elimination system. You left out discharge.
I cannot believe that I did that, Commissioner Thompson, but my mistake, I apologize.
Commissioner Dominguez.
Thank you, Madam Hearing Officer. Good morning, Mr. DeSalan. Thank you for your testimony today.
Good morning, Commissioner Dominguez.
I'm going to work through a few clarifications of some of your testimony and then lean a little bit on your years of rulemaking experience, and hopefully I can get through those questions without Council Fox objecting. So we'll give it a shot here. So a follow-up question from Commissioner Brancard regarding definitions not used in the rule, but they're used in permits. So along with permits, there's a number of documents that are outcroppings of the Water Quality Act or a rule, whether that be guidance documents or groundwater management plans, so forth like that. It seems a little bit monumental to try to define every term used in those permits or guidance documents, trying to define those in a rule, because we're in a continual hamster wheel of those documents changing. It would seem like it would cause the commission to have to look into a crystal ball of knowing what terms might be used in a permit to even try to cover the gamut of that. So I'm trying to wrap my head around that. So
I don't think so. I think
your
it's
understanding from your testimony
bad audio.
is, I think,
Sounds like him though. You're right.
is that you're falling back on for the most part, the legislative drafting manual that specifically states do not define terms that are not used in the bill, but here it's in the rule.
Yeah,
So it's your testimony that only the terms that are actually used in the rule should be defined in the rule, including not defining terms that are used in another definition. Is that your testimony?
Commissioner Dominguez, Mr. Chairman, members of the commission, yes, that I think describes my testimony quite well.
Okay, you referred to the legislative drafting manual, and you've specifically referred to 1.24.10.12a, and you specifically read the language there, and there seems to be a little bit of a different interpretation from your testimony and Environment Department's testimony. The question I have for you is, if the State Rules Act or the Commission's rule on rulemaking or the State Records Center, their rule is silent towards a particular issue, should the commission look to the legislative drafting manual as a guidance document?
Commissioner Dominguez, Mr. Chairman, members of the commission, yes, I think it is a guidance. I mean, I don't think that the drafting manual would be binding on the commission, because I think it says it shall be guided by. So the word guide is in there, but it certainly seems to me that the commission in adopting rules should follow that the drafting manual to the extent that it can, unless there's a very good reason to deviate from it. And in this proceeding, the testimony from the Environment Department does not indicate to me that there is any good reason for in any way deviating from the Legislative Council Services drafting manual.
Okay, thank you, Mr. Salem. In your written testimony, Amigos Bravos has proposed a minor change to the definition of produced water. And for the most part, it's a fairly minor change. Am I correct from my reading that there's a definition of produced water in the Water Quality Act, as well as this definition in this proposed rule?
I would have to check for sure. I don't, off the top of my head, I do not recall if there is a definition of produced water in the Water Quality Act. It seems to me that there may have been such a definition added as a result of the Produce Water Act, but I don't recall off the top of my head. I'd have to go back and look at the statute.
And that's fair enough, because that was not part of your direct testimony. But based on your multiple years of rulemaking background, isn't it correct that under the State Rules Act, it specifically indicates a word or phrase that is defined in an applicable statute should not be defined in the rule? Meaning if there's a definition in the Water Quality Act, we do not repeat it in a subsequent rule. Is that your understanding of the State Rules Act?
Uh,
And I can give you a specific citation if that makes Council Fox more comfortable. 14-4-5.7B
Okay.
under the State Rules Act.
Okay, Commissioner Dominguez, Mr. Chair, members of the commission. I do seem to recall that provision being in there, so I'll take your word for it.
Okay.
I think that would be grounds for deleting another definition here. But on the other hand, I personally see some value in having terms that are defined in the statute, repeated in the regulations, because then you have all of the definitions there in one place. So I would not recommend following that particular provision of the regulations, but certainly the commission could do so if you think that that would help to simplify the rule.
Okay, let's firstly go with my assumption that they do mirror each other at the beginning, but then it's expanded on in the rule itself. So you have two terms then, one defined in statute, one defined in rule. And the State Rules Act then goes on to indicate a conflict between a definition that appears in a rule and in an applicable statute is resolved in favor of the statute. So even if the commission was trying to make it more clear in the rule to help with administration of the rule, the statutory definition overrides that. So can the commission even go down that path?
Commissioner Dominguez, Mr. Chairman, members of the commission, as long as the definition in the regulations that the commission would adopt is either identical to the statutory definition or entirely consistent with the statutory definition, then yes, the commission can go down that path. I've certainly seen examples where the definition in the regulations will be more specific, will include more terms than the definition that's in the statute. The two definitions have to be consistent, but the regulatory definition can be more detailed.
Okay, thank you, Mr. DeSalen. I believe that's all the questions I have, Madam Chairman.
Thank you, Commissioner Dominguez. Commissioner McWilliams?
I have no questions.
Okay. Vice Chair Armstrong? Okay. Commissioner Fry?
No questions.
All right. And if you would introduce yourself.
Good morning. I came up here prematurely. I'm Carrie Olson representing NMOGA, and I believe I'm first in cross-examination.
I think you are. So I think if there are no more commission questions, we can go to you, and you're in a good place to conduct cross.
Okay, great. Good morning, Mr. DeSalen. Getting used to the microphone again.
Good morning, Ms. Olson.
Carrie Olson on behalf of NMOGA. I just have a few questions for you this morning to the beginning of my outline. So I just want to start with the background in your testimony and the background that you gave this morning. You summarized extensive experience working on drafting regulations. And I think you started with your time at the EPA, is that correct?
That's correct.
And then I think some of the recent examples you listed, you stated that you participated in the triennial review before the WQCC.
That's correct.
And that was on behalf of an interested party, not on behalf of the commission. Is that correct?
That's correct.
And the same is true for your participation in the Clean Cars Rule. You weren't acting on behalf of the Albuquerque Bernalillo County Air Board. It was on behalf of the interested third party.
Yes, I was representing a nonprofit organization and a number of nonprofit organizations. But no, in those rulemaking proceedings, I was not representing the board or commission that were adopting the rules.
And I apologize if you said this already, but you've reviewed the department's rebuttal exhibit 175 with their additional proposed red lines to the rule, which I'll refer to as the new Part 8 that's pending in this rulemaking.
Yes, I have reviewed it. I don't remember it all. I haven't memorized it all, but I have reviewed it.
And have you also reviewed Ms. Fulham, the department witness's rebuttal testimony addressing some of the changes that the department proposed in that exhibit? And I believe that's NMED exhibit 176.
Yes, I have reviewed that.
Do you support the department's proposed revisions to 20.6.8.2, which is the scope section, to clarify the new Part 8 is intended to apply only to permits and discharges regulated by NMED?
I don't believe we have taken a position on that particular proposal.
Okay, so your testimony for clarification is you're not taking a position?
I think that's correct. Our counsel may revise that in the post-hearing briefing, but at least right now, as far as I'm aware, we have not taken a position on that.
And is it your understanding the rule as proposed before the department proposes regulations, the scope applies to all persons subject to the Water Quality Act? We can look at the scope section.
Yes, I would agree with that.
And in your extensive background and experience and work before these agencies, are you aware the Oil Conservation Division is delegated authority by the Commission to administer the Water Quality Act regulations pertaining to disposition of produced water from oil and gas related activities that are subject to the Water Quality Act?
Yes, I think historically that has been the case, but I think that the Produce Water Act has changed those responsibilities somewhat.
Okay, are you aware of something specific where the Water Quality Control Commission has revoked delegation to the Oil Conservation Division?
No, I am not.
Objection outside the scope. I've sort of let this go for a few questions, but this entire line of questioning has been outside the scope.
Yeah, Ms. Olson?
Well, I believe Mr. DeSalen's been presented as an expert on the drafted rule and providing information. So if I can't ask him about the drafted rule, I'm not clear what his role is here.
Okay, so repeat your last question.
Well, he already answered it. Do we need to go through it again?
No. All right, sorry, then what's your next question?
Okay. And so if we go to the objective of this Part 8, will you agree with me that an objective of the Part 8 is to supplement the Commission's existing Part 2, 20.6.2?
Say that again?
Do you agree that the objective of the rule Part 8 is to supplement the Commission's existing 20.6.2?
Yes, I think so.
And this goes to the definitions, which I believe you've testified to.
the Oil Conservation Division is designated by WQCC as a constituent agency. Is that your understanding?
Yes, that's correct.
And the OCD would therefore fall into the definition of department under 26.2, but it does not fall into the definition of department under the new proposed Part 8. Is that your understanding?
That is not an issue that I addressed in my testimony. So I mean, I would have to look at that and see how the definitions fit together, how the different regulations fit together. So off the top of my head, I don't think I can answer that.
Okay, in your knowledge and experience in legislative drafting and working on regulations, would you agree with me that if those definitions are inconsistent, that could be a source of confusion if it's not addressed in this rulemaking?
Objection vague.
Right, it does sound vague. And I think you're inviting speculation unless you have an example of inconsistency in the record.
Well, that is the example, the definition of department, and I thought Mr. DeSalen was here as an expert.
Sure, he's here in connection with the testimony that he gave, but I think you're asking him to speculate on something that he didn't testify about.
Well, I believe he's here today testifying to problems with the definition section, and I'm asking him about a problem with the definition section and asking if in his knowledge and experience that could be a source of confusion. I think he can answer, I don't know, if he doesn't know.
Okay, but you haven't pointed to, or at least I didn't hear it, definitions that are inconsistent between 20.6.2 and 20.6.8.
I can repeat the question. My question is about the definition of department.
Oh, okay. Okay.
I can repeat the question. Do you agree that if 20.6.8 is defining department one way and 20.6.2 is defining department another way, that could be a source of confusion if it's not addressed in this rulemaking?
Again, I would have to look at the structure of the two different rules, which I have not done for purposes of my testimony today. And see how the two rules fit together. There are certainly examples of different bodies of regulations that define the same term differently. Sometimes that's totally appropriate. There are other times when it can create problems. I don't know about this particular set of rules.
Understood. And going back to your testimony earlier was that you do understand this Part 8 supplements the existing Part 2. So going back to that, is it your general understanding that the definitions in 20.6.2.7 would apply unless they're specifically modified by the proposed Part 8?
I think that's right. But again, I'd have to think some more about how these rules fit together. And again, I haven't done that for purposes of my testimony today.
Okay, are you aware that a number of the definitions in 20.6.8 merely cite to a corresponding definition in 20.6.2?
Yes, I am.
Do you agree it could create confusion if Part A does that with some, but not all definitions from 20.6.2?
I don't know that it would create confusion, but I definitely think there is some merit to doing that type of cross definition consistently.
And switching gears a little bit, were you here for the department's opening statements and testimony?
I was here for the department's opening statement and some of the department's testimony, but not all of it.
And it's been a few months, so it's probably a little rusty on all of us.
I'm afraid so, yes.
Do you recall hearing the department's the part of the opening statement explaining this rule is intended to set up a framework to guide future rules?
Yes, I do remember hearing that statement during the opening statement.
And do you understand that to mean that this would be potentially a first step in a multi-step process going forward?
Potentially, but not necessarily.
Would you agree with me that it may be difficult for stakeholders to understand or evaluate the real impact of the rule from only the framework that has been provided without seeing how the definitions would potentially be used in the future?
Objection outside the scope.
Yeah, I'm not sure I was able to follow that actually.
Well, I understand Mr. DeSalan to be raising concern about definitions that are used in the rule that aren't found in the rule that could potentially be used in a future permit. So I'm not quite clear why Ms. Fox is saying that my question about the future rule is outside the scope.
Right. So he did testify that to the extent terms needed to be defined in the future, they could be defined, I think, in the future. So if you would please repeat your question.
Okay. Do you think it's difficult for stakeholders to understand or evaluate the impact of this rule from only the framework that has been provided?
As to some of the things that, some of the definitions, for example, that we recommended be removed, yes, I think that definitely can cause confusion to stakeholders, and that is why we recommended that they be removed. But there are other provisions in this rule that we think are very important and don't create any confusion and can be adopted now.
So you agree it would be difficult for the stakeholders or the commission to understand whether or evaluate whether a proposed definition is accurate without knowing how the term will be used in the future?
To the extent that it's a definition that is not used in the body of the rule, yes, that's my testimony.
I'm just skipping over a few of the things that have already been asked. So I believe Commissioner Dominguez asked you about definitions used in the Produced Water Act, or maybe just in the Water Quality Act. Specifically, he asked you about the term produced water. You responded that you weren't aware whether the term produced water was defined in the Water Quality Act. Was that accurate?
I don't think I used the word I wasn't aware. I just wasn't sure. I know I have looked at these provisions before, and several months ago, I might have had it at the top of my head that yes, there's a definition, a new definition of produced water that was added by the Produced Water Act and included in the Water Quality Act. At this point, I'd have to go back and look to refresh my memory to recall if that is the case. So I take an issue with the word aware. I don't recall at this point.
Okay, so that's with the Water Quality Act and the Produced Water Act. You don't know sitting here today whether produced water is defined in either of those acts?
I don't recall.
Sure.
I think that it is, but I don't recall for sure.
Okay. So I think the scope of Commissioner Dominguez first asked you about repeating a statutory definition, but he also asked you about consistency with definitions. And just for clarification of the record, you agree the Water Quality Control Commission doesn't have authority to define a term in a way that is inconsistent with the statutory definition in either the Water Quality Act or the Produced Water Act?
Um, if I understand your question correctly, Ms. Olson, yes, I agreed that a definition in the regulation should not be inconsistent with the definition in the statute.
And do you agree that some of the drafting concerns you raise in your rebuttal and direct testimony could create problems for implementation of the rule down the line?
I think the problems are that it creates confusion. Whether it would create problems, I'm not sure. I don't think that was my testimony.
So in your knowledge and experience, do you agree there's a concern with implementation if the drafting concerns are not addressed?
If there are legitimate drafting concerns with the proposed rule and those concerns are not addressed, then yes, it can create problems in the future, certainly.
And is it your testimony that the concerns you've raised are legitimate drafting concerns?
Yes, they are. Whether every one of the issues that we raised are things that could create significant problems in the future, I'd have to go back and look through them. They certainly will create confusion and potential problems, but I don't know if I would agree with your statement as to every one of the regulatory changes that we have proposed.
Okay, that's all the questions I have. Thank you.
Okay, thank you, Ms. Olson. I neglected to check with the commissioners on the platform to see if they had questions. I believe Commissioner Rosatos, do you have a question of Mr. DeSalen?
Thank you, Madam Examiner. No, I do not have any questions. I appreciate it.
Thank you. Are there other commissioners on the platform? Okay, thank you, Pam. In that case, let's go to Mr. Maxwell. Mr. Maxwell, do you have questions of Mr. DeSalen?
Your Honor, commission members have probed into my questions. I have no questions today. Thank you, Mr.
All right.
DeSalen, for being here.
Thank you. Ms. Taylor? Mr. Cox?
No questions.
Thank you. Mr. Hightower? Okay. Mr. Davis? All right. Ms. Nanasi or Mr. Dodd? All right.
Good morning, Mr. DeSalen. My name is Chris Dodd. I represent New Energy Economy.
Good morning, Mr. Dodd.
First, I want to talk to you about the excess use of definitions in the proposed rule. You agree that there are too many definitions contained in this proposed rule?
It's not so much that there are too many as that there are a number that are unnecessary.
And that they're unnecessary because they're either not used in the rule at all or they're only used in defining other terms?
That's correct.
For example, I believe you testified on rebuttal that approximately 8 of the definitions are used only in other definitions, which creates a needlessly complex and convoluted structure?
That's correct. I don't think that number was what I most recently testified to, and I don't think it's what's in our chart. But yeah, there was some confusion about the numbers.
Yeah, and I'm not going to quibble with you over the number of definitions.
I can see that.
Great. So basically, your testimony is that you should only use the definitions that are actually needed to make the rule clear. Correct?
I would agree with that, yes.
Basically, keep it simple so that it's easily understandable.
Correct.
Now, I want to walk through a hypothetical, okay?
Okay.
Let's imagine that we're writing a rule dealing with cats and dogs on public sidewalks, okay?
Okay.
In the initial draft of this rule, we have a definition section that includes 3 definitions.
That includes what?
3 definitions.
Okay.
First, cat means the domesticated mammal of the species Felis catus. Okay.
Okay.
Second, dog means the domesticated mammal of the species Canis familiaris. Okay.
Okay.
And third, domestic animals, which means cats and dogs. Right.
Okay.
And then we have the operative language of the regulation, which states, quote, no domestic animals are allowed on public sidewalks, close quote. All right.
Okay.
Now, in this situation, we're using domestic animals to define, or basically to encompass cats and dogs. But you would agree that it would be better to simply cut the definition of domestic animals and simply make the operative language of the regulation state, quote, no cats or dogs are allowed on public sidewalks, right?
I think that's right, yes.
Because it's more clear, correct? It removes complexity and convoluted structure.
Correct.
And it also helps remove a definition for domestic animals, which by common sense might include more than just cats and dogs, right?
Correct.
So with this hypothetical in mind, I want to talk about the definitions for bench scale project, pilot project, and demonstration project, which are contained in both Amigos Bravos / Sierra Club's proposed rule and NMED's proposed rule. Okay?
Okay.
Under both proposed rules, a bench scale project is, quote, a project or study conducted in a laboratory, close quote, right?
Okay.
Do you agree with that?
Well, I'd have to go back and look.
Please, can you pull up your proposed rule?
I think I can do that. Is this it here?
Thank you, Ms. Fox.
Might be quicker than scrolling through my computer. So we're looking at a definition of
First is the definition of bench scale project.
bench scale project.
And the question was, let me know when you see it.
Okay, I'm there.
So a bench scale project is, quote, a project or study conducted in a laboratory, close quote, correct?
That's correct.
And then if you could flip to the definition for pilot project, please.
Okay, I'm there.
A pilot project is, quote, a representative engineering scale model or prototype system that is beyond the bench scale and tested in a non-laboratory environment. A pilot project represents an increase in the technological scale than otherwise achievable in a laboratory and often involves larger quantities of materials over longer periods of time, close quote. Did I read that correctly?
You did.
And then we get to the definition for demonstration project. You could please go to that definition.
Okay.
A demonstration project is a bench scale or pilot project as defined in the rule, correct?
That's what it says.
And just to be clear, those three definitions are the same in Amigos Bravos and Sierra Club's proposed rule and the proposed rule of NMED, correct?
I believe so, yes.
Now, if you look at the operative portion of the rule, I want to direct you to part 400. Is it correct that the terms bench scale project and pilot project are not used?
Based on a very quick review of the regulation, I think that's correct. Those terms are not used in part 400.
Instead, the term that's used is demonstration project, correct?
Correct.
Wouldn't you agree that just like in my cats and dogs regulation example, that it would be clearer, better drafting to get rid of this term demonstration project and simply use the terms bench scale project and pilot project throughout the entire rule?
Off the top of my head, I would agree with you, but this is not an issue that I testified about. This is not a proposal that we made. And I would really have to think about it some more and look at the rule and the structure of the rule some more before I could give you a definitive answer to your question.
Okay. If pilot project, the term pilot project and the term bench scale project are not used anywhere else in the rule and are only contained within the definition for demonstration project, if that's correct, would you agree that we ought to just get rid of the concept of demonstration project, get rid of that definition, and just use the actual terms that we intend to be covered in the rule?
Yes, it seems to me that that would be a simpler way to approach it. But again, I didn't look at this rule carefully with that issue in mind. So I don't feel comfortable giving you an absolutely definitive answer, but I think I agree with what your point is.
Thank you. Now I want to talk to you about the permitting process contemplated by both Amigos Bravos and Sierra Club's proposed rule and the proposed rule of NMED. Okay.
Okay.
Neither NMED's proposed rule nor Amigos Bravos / Sierra Club's proposed rule requires that a person obtain a permit prior to using produced water for pilot projects and bench scale projects, correct?
I think that's correct.
Instead, both proposed rules contemplate a notice of intent and determination of, quote, no discharge permit required, close quote, prior to the project being conducted, right?
That's my understanding.
And so these rules do not require a permit to use produced water off of the oil field, correct?
Under certain circumstances, that is correct, yes.
Now, I'd like to read you a few statutory provisions and ask you a couple of questions about them as they apply to these proposed rules, okay?
Okay.
You're familiar with the Produced Water Act, right?
I'm sorry?
You are familiar with the Produced Water Act?
I've read it. I've read it probably a few times, but I've never implemented. I've never become really familiar with it. So yeah, I have general familiarity with it.
Okay.
But that's all.
So section 70-13-3B, which is a portion of the Produced Water Act, states that, quote, it is the jurisdiction of the Water Quality Control Commission to regulate produced water as provided in the Water Quality Act, right?
Yes, I recall that, and that sort of harkens back to my response to some of the questions of Ms. Olson.
Sure. And section 70-13-4D, another provision of the Produced Water Act, states, quote, for uses regulated by the Water Quality Control Commission pursuant to the Water Quality Act, a person shall obtain a permit from the Department of Environment before using the produced water, the recycled or treated water, or treated product, or any byproduct of the produced water, close quote. Did I read that correctly?
Well, I don't have the statute in front of me. That sounds familiar, but I can't promise you that that's correct.
Okay. Now, and just for the record, I would note that that statute is contained at NMED Exhibit 19, Bates number 000263. Now, that portion that I just read, what that means is that prior to using produced water in any way that is subject to regulation by the Water Quality Control Commission, a person has to get a permit from the NMED, correct?
We are getting into an issue in the statute that we have not, Amigos Bravos and the Sierra Club have not taken a position on, so far as I'm aware. There's a question there, I think, and I think this is what you're getting at, as to whether the Produce Water Act expands the authority of the Water Quality Control Commission beyond what's already in the Water Quality Control Act. And my interpretation of the Produce Water Act is that, yes, it does. But I don't think that there is any definitive interpretation, and I think the statute is probably at least somewhat ambiguous on that point.
Okay. Now, the Water Quality Act, that is Chapter 74, Article 6 of the New Mexico statutes.
That's correct.
And you are aware that the bill that enacted the Produced Water Act also amended the Water Quality Act.
That's correct.
The legislature did two main things to amend the Water Quality Act when it enacted that bill, right?
You could characterize it that way, yes.
The legislature defined produced water in section 74-6-2, which is the definition section of the Water Quality Act, correct?
Okay.
Does that sound familiar to you?
That sounds correct, yes.
And then the legislature also added an additional duty of the Water Quality Control Commission under the Water Quality Act, correct?
That's correct.
And that is subsection P of section 74-6-4, correct?
I don't remember specifically what the subsection letter is, but it would be somewhere around that, yes.
And so in that statute, it says the commission shall, and then it lists lots and lots of different requirements under the WQA.
Right.
And subsection P states the commission shall at the top, P, adopt regulations for the discharge, handling, transport, storage, recycling, or treatment for the disposition of treated produced water, including disposition in road construction maintenance, roadway ice or dust control or other construction, or in the application of treated produced water to land for activities unrelated to the exploration, drilling, production, treatment, or refinement of oil and gas. Correct?
That sounds very familiar, yes.
And so, wouldn't you agree that if someone wants to discharge, handle, transport, store, recycle, or treat produced water, they need to first obtain a permit?
Madam Hearing Examiner.
Objection outside the scope.
Yeah, Mr. Dodd, I don't remember him addressing this angle.
If I could respond briefly, please. This is an expert who's testifying as to the substance of the rules that are proposed by Amigos Bravos and Sierra Club. I'm asking about a particular section of those proposed rules, and that basically they're in conflict with the law. And that's what I'm trying to demonstrate here. And I think that is within the scope of this expert's testimony.
Okay, go ahead.
And so wouldn't you agree that under the statutes, permits are required prior to any use of produced water off of the oil fields?
I think that is an interpretation of that statutory provision that I would probably tend to agree with.
Wouldn't you agree that bench scale projects and pilot projects involve the use of produced water?
Madam Hearing Examiner.
Yes.
I'm over here.
I'm sorry, this is not Namoga's witness, Madam Hearing Officer.
No, I understand. Ms. Olson.
I'm going to object to this questioning on the substance of the rule. Mr. DeSalen's testimony is onto drafting of the rule. I don't think he testifies to permitting or requirements for obtaining permits. And I also don't see in his testimony where he testifies to interpretation of the statute.
All right, and I accepted Mr. Dodd's representation that he wanted to explore what he believed was an inconsistency between the proposed changes to the rule made by Amigos Bravos and Sierra Club and New Mexico state law. Have we strayed from that?
No, I can actually just go to my next question, which I think will hit exactly on that.
Okay.
Both NMED's proposed rule and Amigos Bravos and Sierra Club's proposed rule do not require permits for the use of produced water in bench scale and pilot projects, do they?
That's correct.
And you would agree that that is inconsistent with the binding statutory authority, correct?
Not necessarily.
Depends on what interpretation you take of those.
That's right.
Those statutes.
That is correct.
But you said you would tend to agree.
I think that's correct. That was my testimony.
Okay. And so you would tend to agree that these proposed rules are inconsistent with the statutory provisions.
Well, I think I used the word tend to agree in response to a slightly different question. I think my response to that question is I'm not sure.
Okay. Thank you very much. That's all the questions I have.
Okay.
Madam Chair.
Oh, Mr. Commissioner Brankard.
I think there's a really important point here about what's relevant or not. The department makes a proposal. Other parties propose changes. The fact that a party does not make a change to the department's proposal doesn't make it that party's proposal. I think they can only be questioned on their proposed changes, not on other parts of the rule if they didn't propose to change. And that's what I think was going on here.
Okay. All right. Thank you for that. Thank you, Mr. Dodd.
Thank you, Madam Mayor.
Mr. Knight.
Thank you, Madam Hearing Officer, Chair, and Commissioners. I just have a few questions. I think most of my questions were addressed by Commissioners Brankard and Dominguez, but I'll just gonna that clean up here. Mr. DeSalen, good morning.
Morning, Mr. Knight.
You stated previously that you understand that this is a supplemental rule. Is that right?
I don't think I said it was a supplemental rule. I think I agree that it supplements pre-existing rule. I guess that means the same thing, but I just want to make that clear.
Fair enough. You understand that
Bless you.
the department believes it has the need for these definitions for implementation in existing reuse permits, given that this is a supplemental rule for the already codified permitting regulations in 20.6.2. Is that correct?
Yes, I heard the Environment Department witnesses testify that they felt that these rules were necessary for implementation of the current permitting program. I think I disagreed with that conclusion in my testimony.
And you understand that the department's intent with this rule is to create a framework within which all future reuse rules can be located.
Yes, I heard the Environment Department witnesses say that that was their intent. I disagree with the merits of creating a framework that includes definitions that aren't being used in the body of the rule. So yeah, that was the Environment Department's intent, but I don't agree with how they're going about it.
And you understand that this rule pertains to reuse of water from all sources. Is that correct?
By all sources, you mean produce water, industrial wastewater, and domestic wastewater?
Yes.
Yes, the rule in some ways addresses all of those sources of wastewater.
And are you aware that there are definitions for unused terms in other regulations that the department implements?
Sure. I mean, I wasn't there when those regulations were adopted. I didn't have the opportunity to review them and comment on them, or I would have given very much the same comments that I gave here. But yeah, sure. There are lots of mistakes. There are lots of problems in the New Mexico Administrative Code, especially if you look through the whole thing.
And let's see, are you aware that 1.24 NMAC, the rulemaking rule, as we'll call it, identifies the Administrative Law Division of State Records Center and Archives as the delegated entity for determining if a regulation meets style and formatting requirements?
I think that's correct.
And do you recall testimony that was given by the department at the beginning of this hearing that the Administrative Law Division reviewed this rule and did not have any suggested edits in regard to the inclusion of the definitions that you're opposing?
Yes, I heard that testimony, but I don't believe that the Records Center looks for those kind of issues when it reviews a rule.
And would you agree that the commission has the authority to adopt definitions that aid in implementation, even if those terms do not appear in the text of the rule, but that you don't think they should do that in this instance? Is that accurate?
Yeah, I think that the environment, or excuse me, the Water Quality Control Commission has the authority to adopt definitions that aren't used in the rule.
Okay, thank you. That's all the questions.
Okay, thank you very much, Mr. Knight. Anything? Oh, first, let me go to Ms. Fox. Do you have follow-up?
Just one question, Madam Hearing Officer. Mr. DeSalen, today as you sit here, you're not offering an opinion whether the Produced Water Act and the Water Quality Control Act require the department to issue a permit for industrial use or industrial projects or demonstration projects that do not discharge to groundwater or surface water, correct?
I think that's right.
That's all.
Okay, thank you. There's nothing further, and we can excuse, Commissioner Brankard.
Yeah, sorry, I just wanted to follow up on an interesting point made by Mr. Cox about the demonstration project definition. Would another alternative for the commission's consideration be to take the definitions of, bench scale project and pilot project, put those words into the definition of demonstration project, and then eliminate bench scale project and pilot project?
Yes, I think that would make sense. But again, Commissioner Brankard, Mr. Chairman, members of the commission, I haven't looked at it real carefully or closely to analyze how that would work. But as you described it, Commissioner Brankard, I think that would work and it would make sense.
Thank you.
If there's nothing else from the commission, we can excuse Mr. DeSalen. Thank you very much for your testimony, Mr. DeSalen.
Thank you, Madam Hearing Officer, Mr. Chairman, members of the commission.
Right. So I understand, Ms. Fox, we've heard from both of your witnesses. All right. So Ms. Nanasi, NEE would go next. And I understand if you would please just address the order in which we'll hear from your witnesses and the time constraints that I understand some of your witnesses have. There's a handheld mic on the corner there.
Hello. Hello. We are prepared to do opening and start with our first witness, Mr. Gom, and continue throughout the day. And then I believe that I talked to you and the other parties that Mr. Noble is flying in tonight and will be prepared to present his direct and then sit for a cross-examination. So if we're not done with Mr. Gom, I would ask your indulgence because he's flying in to deal with Mr. Noble on Tuesday. If we finish early on Tuesday with Mr. Noble and Mr. Gom has not concluded, then he should go continue on. And then Dr. Van Gogh is prepared to start Wednesday morning after public comment at 10 a.m.
All right.
And Mr. Dodd is going to do opening, and then I will put on the three witnesses.
Thank you.
Thank you.
Mr. Dodd, why don't you go ahead with opening, and we are going to take a break by noon because we're returning for a 1 p.m. public comment. But let's see if we can't at least get the opening.
I should be able to get over.
All right.
Yeah, just one moment to grab some.
Okay.
Mr. Chairman, members of the commission, Madam Hearing Officer, I'd like to begin my opening by discussing one of the concerns raised by Commissioner Brankard in his questioning of NMED's witnesses. The breadth of the WQCC's authority and duty to regulate produced water. Your duty and authority is clear and expansive. It is your authority and duty to regulate produced water in New Mexico off of the oil field. Off of the oil field. What is the scope of that duty and authority? As former New Mexico Supreme Court Chief Justice Charlie Daniels would always command, read the statute. And so let's turn to section 74-6-4P. It states that the commission shall adopt regulations to be administered by the Department of the Environment for the discharge, handling, transport, storage, recycling, or treatment for the disposition of treated produced water, including disposition in road maintenance and road construction maintenance, roadway ice or dust control, or other construction, or in the application of treated produced water for activities unrelated to the exploration, drilling, production, treatment, or refinement of oil and gas. This says that you shall adopt regulations, but it does not say what those regulations have to be. They can be prohibition. And New Energy Economy is here to tell you that the science, as you've heard from NMED, does not support any use of produced water off the oil field. Even the science that NMOGA has put forward, which we'll hear about more, Exhibit 139, which was published in April of 2024, tells simply to do more science, that no uses have been determined to be protective of health, safety, and the environment. One of the things that this commission should consider is the legislative intent behind the Produced Water Act. As former Speaker of the House Brian Egolf, the sponsor of the Produced Water Act, explained in his correspondence to the Oil Conservation Commission, the Produced Water Act stripped the OCD of its authority over the use of produced water outside of oil and gas industries. Speaker Egolf's correspondence is New Energy Economy Exhibit 3, and I have copies for the members of the commission and for the parties. May I approach? Thank you. Speaker Egolf wrote, quote, "This act clearly removed that authority from OCD and established instead that the Water Quality Control Commission and the New Mexico Environment Department shall regulate all aspects of any off-oil field use of produced water. The legislation thereby clearly established that the use of produced water outside of the oil field shall be the responsibility of those public bodies charged with the protection of New Mexico's water quality and environmental security. The Water Quality Control Commission is also instructed, specifically by statute, to employ sound, credible scientific data and to protect public health and welfare," close quote. NMED is trying to do its job. Energy Economy acknowledges that. But NMED has erroneously embraced a narrow, mistaken reading of the applicable statutes, and thus the proposed rule is a reflection of their misunderstanding of the law. The water quality folks at NMED are used to operating within the traditionally constrictive confines of the Water Quality Act, and so it is surprising that they would read the Produced Water Act provisions and view them through the narrow lens of the WQA and the mistaken belief that they can only require permits for discharges. This is incorrect. Subsection P is a provision of the Water Quality Act, and it requires the Commission to establish comprehensive regulations to control all aspects of off-oil field discharge, handling, transport, storage, recycling, or treatment of produced water. Accordingly, Section 70-13-4D provides, quote, for uses regulated by the Water Quality Control Commission pursuant to the Water Quality Act, a person shall obtain a permit from the Department of Environment before using the produced water. Close quote. That is the law, and it is clear. Any use of produced water outside of the oil fields requires a permit. The current pilot projects are in violation of the law because they do not have permits. By law, this Commission's regulation must require permits for any use of produced water or its byproducts. By law, permits are required for any use. The proposed regulation falls short of the statutory command. Exhibit NG 21, which is an exhibit to Mr. Gaum's rebuttal testimony, which is New Energy Economy Exhibit 18, complies with the law. And I'd like to hand out copies of that exhibit to the Commission. May I approach? We are requesting that the Commission adopt our proposed regulation. It is the only regulation that has been proposed that complies with the requirements of the WQA and the Produced Water Act. In his correspondence to OCD, Speaker Egolf further wrote, quote, I urge you to take care in crafting of these regulations to ensure that none of the rules and regulations adopted pursuant to House Bill 546 inadvertently allow or purport to permit any use, application, or discharge of produced water outside of oil and gas operations. The people of New Mexico will be best served by the adoption of stringent regulations of produced water that put public health and safety first, and clearly state that any use of produced water outside of oil and gas operations is prohibited, close quote. Speaker Egolf concludes his correspondence writing back in 2020, quote, currently, several universities are conducting research into the reuse of produced water and whether uses of produced water present health and safety risks to the public and our natural resources. The New Mexico Environment Department and the Water Quality Control Commission will be the agencies best equipped to evaluate any such research when it is complete. At this time, I am unaware of any safe, fully researched application for produced water outside of oil and gas operations, close quote. Since 2020, when Speaker Egolf wrote those words, the science has become clear on only one thing. Permian Basin produced water contains radioactive nuclides, forever chemicals, heavy metals, and a litany of carcinogenic compounds, as well as hundreds of unidentified chemical constituents. The research has not demonstrated the safety of reuse of produced water. The science has simply shown us how much more science we have to do before the use of produced water can be contemplated. I have one additional exhibit that I'd like the Commission to consider with my opening, and that is New Energy Economy Exhibit 13. This document is New Energy Economy's requests of the Commission in a non-technical rule-based format, but more in natural language. May I approach? New Energy Economy requests that the Commission adopt a regulation, one, that prohibits the discharge, handling, transport, storage, recycling, or treatment of treated or untreated produced water for any activities unrelated to the exploration, drilling, production, treatment, or refinement of oil and gas, except as the NMED authorizes by permit. Two, that NMED shall deny certification of any federal permit proposing to discharge, dispose of, or reuse treated or untreated produced water for any activities unrelated to the exploration, drilling, production, treatment, or refinement of oil and gas. Three, that establishes that the only exception to the prohibition on the use of produced water is for bona fide research purposes, and that any person or entity desiring to conduct such research shall, prior to using produced water, submit a produced water research application for permit to NMED. Four, that the application must provide all of the information and satisfy all of the requirements contained within the currently proposed rule, but also that the application must establish that the benefit of conducting the proposed research outweighs the potential risks posed to health, safety, and the environment by the proposed use of produced water in the research. This requires the applicant to explain the value of the proposed research and to identify any risks posed by the use of produced water. By way of illustration, if an applicant were to propose a produced water pilot project on the banks of the Rio Grande, just upstream from the Bosque del Apache National Wildlife Refuge, NMED could look at that and say, you know, we like the research you guys are trying to do, but it's too risky, right? If you have a failure at that project, you're going to demolish this national treasure. And so, no, we're not going to allow it. That's what we're trying to get at here, that you have to weigh the risks and the benefits of the proposed research. Five, that NMED has the discretion to request any additional information needed to determine whether to issue the research permit. Right? That way, NMED can have all of the information that it needs. And six, that NMED will only issue that research permit if it determines that the benefit of conducting the proposed research outweighs the potential risks posed to health, safety, and the environment by the proposed use of produced water. This means that if NMED determines that the risk posed by any applicant outweigh the potential benefits, NMED, as the regulator, shall deny the application. You have heard from every single party in this case that there are currently no scientific standards that underlie this rule, and that without scientific standards, the Commission cannot allow the discharge of handling, transport, storage, recycling, or treatment of produced water. Ultimately, New Energy Economy's position is that NMED's narrow, mistaken interpretation of the statutes resulted in a rule that does not meet this Commission's expansive duty to protect the safety, welfare, and environment from the risks posed by produced water. The proposed rule does not comply with the requirements of law, and it must be modified. The law requires permits for any off-oil field use of produced water, and thus the proposed rule is in violation of that requirement. Why did the legislature require a permit? Because no permit means no notice, means no opportunity to be heard. And that's a violation of due process. The persons that could be harmed by the use of produced water have a right to a permitting process where they can be heard and testify about the potential pitfalls of the proposed use of produced water in research. New Energy Economy's position is that the commission must modify NMED's proposed rule, or it will be nullified by the appellate court. As all environmental groups are, New Energy Economy is concerned about there being sufficient water resources in the future. But this proposed rule is not the answer. The need for good, clean water means we must trust science and protect our existing water supplies from unknown proprietary chemicals that the oil and gas industry refuses to identify. Regulations are risk management, and they require balancing. Regulators must weigh the risk of the enormous irreparable harm posed by the use of produced water outside the oil fields. Not only is there no evidence that produced water can be safely used, the evidence shows that it can't be. Thank you.
Okay, thank you, Mr. Dodd. You have brought us to 11:55. So let's break until 1 when we return. I'm sorry, yes?
I apologize. Can I move in New Energy Economy exhibits 3 and 13, please?
Okay, are there objections from other parties? 3 and 13.
Your Honor, this is Mr. Maxwell. I object.
What's the nature of your objection?
We haven't heard any expert witness testimony to lay the foundation for these exhibits. I would say we need to wait until then.
All right, so let's take this up later after your witnesses, Mr. Dodd. All right, again, now it's 11:56. We'll return at 1 and accept public comment at that time. Let's prepare to begin, please. Let's come back from the break. Good afternoon. My name is Felicia Orth. I'm a hearing officer appointed by the Water Quality Control Commission to conduct the hearing in case number WQCC 23-84. This is a water reuse rule. We have come to one of many parts of this hearing where we invite public comment. Just a couple of rules about public comment. I will ask you to spell your name. I will ask you to swear or affirm that you will tell the truth. And I will be timing the comments. Unfortunately, there are so many folks who want to offer public comment. I have to limit them to 3 minutes. Please collect your thoughts. I can only call on you once. If you have more to say than can fit in 3 minutes, please write up your comments and email them to M. Jones. Her contact information as part of the public notice. Anything you write will be given the same weight as what you've said here. So I have, excuse me, 3 people in the room who indicated a desire to offer comment today, and about a dozen folks on the platform who indicated a desire to offer public comment. Know that this is the first of 10 opportunities we expect you will have. We do invite public comment twice every day. Today it's 1 in 5. Tomorrow, Wednesday, Thursday, Friday, as necessary, it will be at 9 and 1. So let me mention the first 3 folks in the room. I have Larry Pierce, J. Paul McWilliams, and Ray Allen Smith. Is Mr. Pierce here? All right. If he rejoins us, I'll invite his comment. Mr. McWilliams. No. Okay. And Ray Ellen Smith. Ah, great. So I'm going to ask you to come to a microphone there. Make sure it's green. And spell your name, both of your names, please, first.
Rayellen, Rayellen. Last name is Smith.
Okay, thank you. Do you swear or affirm to tell the truth?
Absolutely, yes.
Okay, thank you. I'm going to start your time.
Thank you. Good afternoon. My name is Rayellen Smith. I'm here representing Indivisible Albuquerque and Reboot Our Democracy with over 2,000 concerned New Mexicans from around the state. Today, we stand united with our allies from Yucca, Food and Water Watch, No False Solutions Coalition, and 40 other organizations from around New Mexico. We're here to present this petition, which I have in my bag and I'll grab. Signed by over 1,000 New Mexicans urging the Water Quality Control Commission to amend the proposed wastewater reuse rule. This rule, as it stands, poses significant risk to our environment, land, water, and public health. The rule as it stands now is incomplete, ambiguous, and unclear. It lacks scientific standards to measure water quality, which are the most important part of the rule, and I'm baffled as to why we're here before you today without those standards. How can you, as commissioners, evaluate the quality of the rule without the very standards upon which the rule is built? Because of the lack of any definition of water quality standards, we, the public, and concerned citizens believe there is intent to occlude those standards and push this rule through without them. That leaves us very uneasy about demonstration projects and pilot projects as referenced in the rule. We know only 13% of the content in fracking waste is identifiable and are held as trade secrets. The rest are held as trade secrets, so we're not clear on how the standards can even be written. Additionally, the rule should include a provision demanding identification of all components of produced water, as is required by legislation in many other states. Further, it is the use of the term reuse in this rule, which gives way for produced water to be reused for agriculture, irrigation, potable water supplies, and aquifer recharge. Without these scientific standards to define how the water will be treated, we feel the risks are quite high for discharge permits to be granted that would allow untreated and poisonous water back to the farms, aquifers, and drinking water sources. Given our staffing shortages in our state agencies, including and especially at the New Mexico Environmental Department, we feel certain that testing, monitoring, and rule enforcement will be quite difficult. Finally, we all understand the need for this rule to provide a method of disposal of fracking waste sludge, since the current method of using injection wells causes earthquakes. We believe the profits from the oil and gas companies who benefit from this rule should pay all the costs for it. This should not be a bailout for multi-billion-dollar companies, and not one penny of New Mexico tax dollars should be used to pay for it. We call for an alternative rule that includes sound and industry testing scientific standards that clearly disallows any discharge of water not meeting those standards to ever see the ground, an aquifer, a green chili farm, or my kitchen faucet. Our communities cannot afford to be the testing grounds for unproven and unsafe practices. Thank you for your consideration.
Thank you very much, Ms. Smith. Savannah Woods, you may be on the platform. Can you unmute yourself? Oh, all right. Again, I'm just going to move through the names. In the event anyone whose name I call isn't available at that moment, they can always rejoin us. Noreen Kelly. Noreen Kelly. Okay. There's another representative of Indivisible Albuquerque, Edna. I have just a first name. Oh, okay. Edna's in the room. Terrific. Come on up. If you would please spell your first and last name.
Edna Lohman, Lohman.
Thank you. Do you swear or affirm to tell the truth?
Yes.
Thank you. I'll start your 3 minutes now.
Okay. I'm a retired environmental and resource economist from Purdue University for 30 years. So I'm fairly new to this area, but I'm learning. Others have addressed the impossibility of safe reuse of fracking waste. I want to address the faulty economics in the governor's strategic water supply plan. Governor Grissom has proposed a $500 million investment for advanced market commitments. This money is proposed to be advanced commitment to purchase commercially treated fracking waste. While this sounds novel and innovative, this finance method has so far been used to finance manufacturing only for vaccines, a situation with known manufacturing methods and a reliable market. Please note that such a secure market situation does not hold here. Treatment methods for produced safe water are yet to be developed, and the future buyers of such water are also uncertain. Furthermore, where and how the state would keep the volumes of reuse water to be stored and how to be transported is totally not unaddressed. So please note that the governor's plan has two purposes. First, solving the problem for the oil and gas industry, and in terms of disposing of waste, of increasing volumes, and second, increasing the supply of usable water. So the second point could perhaps be addressed in other ways. For example, in Israel, they use urban wastewaters for agricultural purposes. That's a lot easier treatment method than with fracking waste. So public investment is important for public goods or nonprofit kinds of goods, such as education and health, things where the commercial market for goods and services would not be providing them. Cleaning up for the oil and gas industry hardly seems like a public good. Instead, the industry should be regulated such that it would have to provide its own cleanup. There are now record profits for oil and gas. Why not let them use their own resources to develop waste handling methods, which of course would have to be approved? Note that the oil and gas development of fracking waste and treatment is already going on in Texas. The methods for providing incentives to industry for its own cleanup are well known: regulation, monitoring, and enforcement. At the same time as regulation, there is a need for better monitoring and enforcement here. My understanding is there are now frequent discharges of waste from fracking, but insufficient monitoring and enforcement. Let's put in for more funding for monitoring and enforcement.
Thank you. If you would offer your written comment to the court reporter, it'll be part of the record.
Okay, this one's all scratched up, so I can do it.
Yes. Thank you very much, Ms. Smith and Ms. Lohman. Joey Smallwood. Is Joey Smallwood in the room or on the platform? No. Marlene Parrott, Sister Parrott? She is, okay.
Good afternoon.
Hello, can you speak up, please?
Can you hear me?
Okay, yeah, it's just keep your voice up, please.
Okay.
If you would please spell your first and last name for the transcripts.
Marlene, Marlene, Parrott, Perrotte.
Thank you. Do you swear or affirm to tell the truth?
I do.
Thank you very much. I'll start your 3 minutes.
My name is Marlene Parrott, a Sister of Mercy, a member of the Partnership for Earth Spirituality, and New Mexico, El Paso Interfaith Power and Light. As a woman of faith, I am concerned about the environmental health impacts on all residents of New Mexico, including all Earth communities. The New Mexico Environment Department's proposed wastewater reuse rule, currently before the Water Quality Control Commission, seeks to address the oil and gas industry's waste problem, produced water, of injection wells causing earthquakes. 2,404 quakes in 2002. The produced water is a toxic liquid waste from private fracking wells, and it is treated as if, and it is going to be treated as if it were water, clean water. The proposed water rule must be an act of moral integrity and uphold the precautionary principle, which states that if an action could harm the public or the environment, the burden of proof falls on those advocating the action. I support a clear, straightforward prohibition against the discharge of untreated and treated produced water to ground and surface water because it can leach into aquifers from the surface and contaminate groundwater. The rule concerns the treatment and reuse of the industry for agriculture, but produced water contains toxic levels of salt, elevated levels of lead and arsenic, and dangerous amounts of radioactive element radium. The Permian Basin, under the EPA's safe drinking water limit of radium, is radioactive. The industry knows their waste contains radioactivity and that there are hazards in trying to treat and reduce and reuse produced water. A 1982 report from the American Petroleum Institute Department of Medicine and Biology states, any control methodology proposed for radioactive materials must recognize the fact that radioactivity cannot be modified or made inert by chemical means. The NMED's mission is to protect and restore the environment and to foster a healthy and prosperous New Mexico for present and future generations. Using the best available science to inform our decision-making in protecting public health and environment must be applied. In the gospel, in the Last Judgment, it says, "Did you give drink to the thirsty?" That implies protecting clean water. Thank you.
Thank you, sister. John Wilkes.
Yes, I'm ready to be sworn.
All right. If you would spell your first and last name for the transcript, please.
John, John, Wilkes, Wilks.
Thank you. And do you swear or affirm to tell the truth?
Yes.
Thank you. I'll start your 3 minutes.
I am John E. Wilkes III, speaking on behalf of the Veterans for Peace, Chapter 63, Albuquerque. Based upon a threat to the public health and the health of oilfield workers, we oppose any reuse of fracking solutions for any purpose. We support a rule that prohibits discharge of untreated or treated produced water into the ground or surface water. The extractive industry refuses to disclose to regulators and the public the chemical content of the substances it introduces into the ground during the fracking process. The industry justifies its policy by not making this voluntary disclosure by claiming that the disclosure would cause harm to the extractors, as it would be a revelation of coveted trade secrets or proprietary information. We dismiss the industry's argument as misleading, false, and arrogant. Extraction is conducted under license or permit. We abhor the fact that the disclosure of the chemical makeup of fracking slurry is not a condition of a drilling permit. Nevertheless, we insist on knowing that of the 1,100 chemicals commonly used by drillers, that have been introduced into the soil and water into the state lands, the commons, or private property. Because oil and gas liquid waste contains PFAS, elevated levels of radium, and organic compounds that are carcinogenic, no reuse of fracking slurry is appropriate. By virtue of gravity, what is put into the soil migrates downward and laterally, possibly invading the water table. New Mexico's soil is rich with beneficial and harmful elements. Bringing active compounds to the surface and not properly handling those elements and compounds is irresponsible. Where uranium, plutonium, radium, thorium, and polonium are brought to the surface by drillers, even in trace amounts, the ambient air and those that inhale the drilling waste vapors are contaminated and risking cancer plus neurological disorders. By its continued contamination and pollution of New Mexico, the federal government considers our state a nuclear sacrifice zone. But Veterans for Peace does not. We urge you to disallow the reuse of any and all fracking waste. Thank you.
Thank you, Mr. Wilkes. Felicia Guillen. What a lovely name. I think we spell it differently, though. Would you spell your first and last name, please?
Yeah, so it's Felicia Guillen, Feleecia, Guillen, Guillen.
Do you swear or affirm to tell the truth?
I do.
All right, I'll start your 3 minutes now.
What was that? Sorry.
I'll start your 3 minutes now. Please pull the microphone closer to you.
Okay, second.
Yeah.
Awesome. Buenas tardes, members of the commission and hearing officer. Thank you for the opportunity to comment on the wastewater reuse rule. My name is Felicia Guillen, and I am a first-generation student at the University of New Mexico. My academic focus includes sustainability and environmental justice, where I advocate and organize for UNM's divestment from fossil fuels. Growing up, my father always emphasized the importance of our water resources. He would always tell me, hija, agua es vida, si no tenemos agua, no tenemos vida, protégelo. His concerns were not abstract, they were rooted in the lived experiences of our community. We constantly worry about water scarcity, fearing that at any moment could be the one when our water runs out. This fear is not unfounded. I was raised in Edgewood, New Mexico, where our relationship with water was also shaped by our dependence on local agriculture. My family regularly buys corn and other produce from Shoybach Farms, a staple of our community. They have the best sweet corn. Recently, they had to sell the farmhouse and 4.5 acres of land because their well ran dry. Although they are currently testing a well that was drilled last fall, they aren't sure what it will produce. Their future is uncertain, and among other things, this serves as yet another reminder of the critical state of our water supply. In New Mexico, we are already contending with water-intensive practices from oil and gas, pecan farming, mega dairies, and alfalfa cultivation. These practices greatly strain our already limited water supply. I hope you understand me when I say that expanding produced water reuse to large-scale industrial and demonstration projects off the oil field without rigorous standards is simply a risk we cannot afford. The rule authorizes reuse in industrial projects and demonstration projects off the oil field, which will lead to projects throughout the state without proper protections. This will undoubtedly result in increased transportation and handling of produced water and a higher likelihood of accidents and spills across the state. Produced water is not just a byproduct. It's toxic and radioactive, posing serious risks to public health and the environment. This is not just an experiment with our water, it's an experiment on our health. Oil and gas liquid waste contains PFAS, elevated levels of radium, and organic compounds that have been proven carcinogenic. Produced water can contain more than 1,100 chemicals, many of which, from my knowledge, are kept secret by the oil and gas industry. Only a fraction of these chemicals have been adequately assessed for health impacts. Additionally, this wastewater often contains heavy metals, which can cause serious health issues, including cancers and neurological disorders. This brings me to my next point. I find it incomprehensible why we would consider using produced water for agricultures and other purposes alike. Our food system is already under immense stress, and introducing produced water, which lacks scientifically based treatment, handling, and disposal standards, would only exacerbate existing problems.
Ms. Guillen, I'm sorry, you've reached your time.
No worries. Thank you so much.
Thank you. And by the way, Ms. Guillen, if you would like to provide your statement in writing, we would be happy to have it in its entirety. Seneca Johnson. On the platform, Pat? No? Okay. But I'm sorry, did someone say something? Okay. Ben Shepherd. Ben Shepherd. Okay.
Good afternoon.
Hello. Will you spell your first and last name, please?
Yes, Ben, Ben Shepherd, Shepperd.
Thank you very much. Do you swear or affirm to tell the truth?
I do.
I'll start your 3 minutes.
Thank you, Chairman Thompson and members of the commission. My name is Ben Shepherd, and I am the president of the Permian Basin Petroleum Association. I appreciate the opportunity to provide comments today. The PBPA is the largest regional trade association in the U.S. and we represent the oil and gas operators in the Permian Basin, as well as the communities that we call home. We advocate on behalf of these operators, large and small, to ensure the safe and responsible development of our natural resources in the Permian Basin region of New Mexico and Texas. As recently shown in the State of the Science Symposium held in Las Cruces on June 27th, New Mexico is a national leader when it comes to the regulation of produced water treatment. The New Mexico Produced Water Consortium is the first science-focused consortium in the United States focused on produced water treatment research. Research performed at the consortium shows that treated produced water has the potential to become a valuable resource for the state of New Mexico. This research needs to continue to move forward, and the commission should send a clear signal to the NMED and stakeholders that it strongly supports the progression of this important effort. Both NMED leadership, the governor's office, as well as industry have stated that they see these rules as an important first step in building the science and data necessary to support broader beneficial use of produced water. However, to achieve this result, it is critical that the final rules issued by the commission address some common sense needs for research to meaningfully move forward. First, there needs to be some indication on the record in this case that the NMED and the commission are willing to consider near-term future rulemakings that potentially allow for discharge of produced water, provided that there is sufficient scientific evidence presented to support such applications. The proposed prohibition on the surface discharge of treated produced water should not apply to treated produced water that is properly handled in proper impoundment and containment facilities. Similar to what is currently done to store raw and recycled produced water under the NMOCD's rules. This includes facilities with secondary and primary containment that utilize leak detection technology. The ability to store produced water in this manner is absolutely essential and necessary to enable new closed-loop projects, both pilot and industrial scale, to explore the co-location of projects, extraction of valuable minerals from produced water, and the use of cutting-edge technologies like membrane distillation, forward osmosis, ultra-high pressure reverse osmosis, and membrane brine concentrators. These innovations have the potential to significantly reduce cost, enhance treatment efforts, and increase scientific knowledge.
Mr. Shepherd,
Third,
please wrap up.
thank you. I appreciate the comment, the ability to comment today. I will submit my comments in writing.
Thank you. Sorelda Snyder Bryan. Oh, yeah. Ms. Bryan, can you hear me? Right, she may have stepped away. John Byram.
Yes, good afternoon.
Oh, hello. Would you spell your first and last name, please?
Yes, it's John, John, and Byram, B as in boy, Yrom as in Mike.
Do you swear or affirm to tell the truth?
I do.
I'll start your 3 minutes now.
Okay, good afternoon, Chairman Thompson and members of the commission. My name is John Byram. I'm Business Development Manager of PESCO. We are a company, family-owned company up here in Farmington, started in 1970. I've lived in New Mexico most of my life and have worked for PESCO for about 8 years now. PESCO was started in 1970. We've grown to over 400 employees, and about 70% of our employee base is Native American. At this point, we make mostly production equipment for the oil and gas industry, but we've been actively in the energy transition space looking to expand our products. And one of those areas is working with New Mexico Tech in their water technology or water treatment technologies. Another area is working with a startup out of Albuquerque on hydrogen generation. So these are a couple of examples of the new technologies we're involved in. I'm also a longtime member of Four Corners Economic Development, and I know how important it is to have access to water resources to grow our business and to add new business for the prosperity of the state. And this is very important in an area in the water scarce area of the Southwest. So hydrogen is just one example of the potential use of produced water. In the San Juan, there's plans to build large solar fields. That power could be used to generate hydrogen. Also, we have vast resources of methane, natural gas up here that also could be used to generate hydrogen. But either way, those are going to require water. And the use of produced water is a natural fit for that. And of course, there's other industrial applications that could be a benefit from produced water as well. New Mexico is a leader in developing technology, and we need to use that technology to solve problems in the state and develop our own jobs here and our own companies here rather than exporting that technology for the benefit of folks in other areas of the country. So I think it's important that we develop standards that protect the public, but then leave it up to the industry to meet those standards. Produced water is right now a waste. It could be a resource. So this decision that the commission will be making will set the course for our state for years to come. So I ask them to please support this economic opportunity for a brighter future for New Mexico. Thank you very much for this opportunity to give my comments.
Thank you, Mr. Byram. Let me call on Ms. Snyder Bryan one more time. Ms. Snyder Bryan, can you hear me?
Yes, I am.
Oh, hello. If you would please spell your entire
Start my
name.
video. Are you
It's
ready
okay.
for me? Thank you for your patience.
Okay, if you would spell your name for the transcript.
My name is Sorelda Snyder Bryan, Cirrelda. Snyder with an I, Bryan with a Y. I live in Bernalillo County.
All right. Do you
Thank
swear
you.
to, hold on one second. Do you swear or affirm to tell the truth?
Yes, I do.
All right. I'm going to start your 3 minutes now.
And my 3 minutes start now.
Yes.
Thank you. I just had a phone call. Thank you, Water Quality Control Commission, for listening to my comment today. I'm glad to be a witness to this wider process to determine how to deal with the huge quantities of fracking wastewater that needs disposal. I appreciate how big your job is to protect citizens of New Mexico in a state, the state that offers the widest array of fuel minerals to be drilled, mined, or processed in our country. As a 50-year resident of either Bernalillo or Sandoval counties, I am a retired APS classroom teacher and environmental educator who created curriculum and taught about groundwater at the New Mexico Museum of Natural History and Science. I lend my voice to the throng saying no to the reuse of fracked wastewater. I am concerned for the health of all of us who live in New Mexico, all wildlife, farmers, dairy and meat producers included. In my own learning about groundwater, I have attended various presentations by hydrologists. One, Bruce Thompson, who's on the commission, presented about use of brackish waters, saline water deposits, rainwater, and fracked water. Another, Norm Gaum, has presented numerous times to the Middle Rio Grande water advocates. I heard both these professionals say no to the use of produced water. I have learned that there is no provision to require permits from the industry that produces water from their waste. Allowing treatment of produced water without permits is wrong. Oil and gas companies have the responsibility, even on private property, to analyze and share with the public the contents of the water to be treated, to list all the pollutants, fracking chemicals, poisons that are found in that water. Chemicals and poisons stay in water, stay in the ground. I have learned from my layperson's study of soil. As a resident voter of this state, I also oppose any state funding to build treatment plants by the industry, and I am very glad my state legislatures refused to authorize this in the 2024 legislative session. Thank you for listening to me. That's the end of my comment.
Thank you very much, Ms. Snyder-Bryan. All right, let me return to the room at this point. Is there anyone in the room who would like to offer public comment at this session? There are many more. I see your hand, sir. Anyone else? Okay. If you would state and spell your name for the record.
My name is Colton Dean, Coltondean.
And do you swear or affirm to tell the truth?
I swear.
Thank you. I'll start your 3 minutes now.
Well, thank you for the opportunity to offer my comments. Today I'm speaking on behalf of the Adelante Progressive Caucus, of which I'm currently the chair of. We all drove here today, and hopefully we all showered this morning. So we have a conundrum. We need both oil and water forever. People need water, and this economy needs oil. However, we live in a landlocked high desert state where ironically oil is more valuable than our water. But we must remember that water is the most valuable resource. Without water, New Mexico turns into the Sahara. We take our oil for granted and we take our water for granted, if not our water more so, since we use it to extract oil. What is the solution when we need both? While oil companies have rightfully earned the public's mistrust with countless environmental disasters, they are in the best position to rebuild that trust. They have us by the tailpipe and by the wallet, but they also have the engineers, the capital, and the energy resources to develop technology to properly clean their fracked water. Even the oil reps will say the treated water is good enough for cotton, but not fruits, vegetables, or livestock. They admit the treated water isn't clean enough. They have to brainstorm other uses for it. Oh, we could use it for hydrogen or something else. So what should the standard be? When produced water can go in one end of a system and oil company representatives eagerly consume the potable water on the other end, then that will be the bridge to rebuilding that trust. And I think that should be the standard, is potable water that could be used anywhere for anyone at any time. Thank you.
Thank you very much, Mr. Dean. Now let me ask back on the platform, is there anyone on the platform who has not yet offered public comment who would like to do so at this time? There will be many more opportunities to offer comment, including 5 p.m. today. Okay. Oh, very sorry. Didn't, wasn't looking in the room again. Hello, if you would state and spell your full name for the transcript.
My name is Susan Timmons. I'm loud. SUSANTIMMONS.
Do you swear or affirm to tell the truth?
Absolutely.
Thank you. I'll start your 3 minutes.
I'm a nurse. I relocated from New Jersey 18 years ago. And I worked in oncology. Okay. I worked in oncology, and which is cancer. And if anybody didn't know that, I'm concerned about the health of people in such an extreme manner that I've been protesting all kinds of things. But this is the most horrendous I've seen yet. That you're going to put polluted water onto crops. I come from New Jersey where corruption is not unusual and where there are cancer clusters all over New Jersey because people are having lead poisoning, mercury poisoning, sick from hydrocarbons. We are, and there's nothing you can do about it there because it's always going to be corrupt apparently in New Jersey. So there's a little corruption here in that people on the board might have vested interests in oil and gas and would only consider their position. I also learned when I came here to New Mexico that water is gold. Water is absolutely gold. It takes 7 gallons of water to produce 1 gallon of gas in fracking. It's an expensive gallon of gas, expensive to the people of New Mexico, the people in Mexico that are getting sick by this as well. When there was a fracking moratorium, I was pleased, and then it quickly disappeared because of corruption. And I would like to see that end. I would like to not see water from fracking or any kind of oil industry water full of carcinogens put on my broccoli. I wouldn't eat another stick of broccoli or a piece of fruit that was produced in this state because I don't want cancer. It has also caused birth defects and a lot of neurological problems. And we have a growing problem with neurological deficits in this country that have been labeled as ALS, that they don't even know what really causes it. They've been labeled as Parkinson's and other neurological diseases they don't even have names for. And we're going to have a city of idiots like they do in China. They call this one city a city of idiots because of the mercury poisoning. I don't want to see that happen here. I love this new state of mind. And I'd rather see that 7 gallons of water be used for people or that fresh water be used to irrigate, not to be used for fracking so they can poison us. And that's the end of my statement.
Okay, thank you, Ms. Timmons. It appears we've reached the end of our public comment session. Again, we will pick up again at 5 p.m. Ms. Guillen, would you come back to the microphone for just one moment, please? At one point, you were saying what your father used to say to you, and I picked up El agua es la vida, right? Water is life, but we wanted to make sure we got the entirety of it.
Yeah. Agua es vida, agua es vida. Si no tenemos agua, no tenemos vida.
Water is life. Water is life. We don't have water. We don't have life.
And then protegerlo, protect it.
Protect it.
Okay. Thank you, Ms. Guillen. Thank you, Ms. O'Grady. All right. Again, we will resume with public comment from both the platform and the room at 5 p.m. and again tomorrow morning at 9 and tomorrow afternoon at 1. Let's go back to our technical testimony. Let's see, Ms. Nanasi and Mr. Gom, I think, is where we're headed next. Mr. Gom, would you state and spell your name for the transcript, please?
My name is Norman Gom, Norman Gaume.
Thank you. And do you swear or affirm to tell the truth?
I swear.
Thank you very much. Ms. Nanasi?
Thank you. For the record, my name is Marielle Nanasi. I'm with New Energy Economy. And before this commission, I present Norman Gaume. Please state your name and spell it for the record.
Norman Gaume, Normangaume.
Did you prepare direct technical testimony and exhibits that New Energy Economy has designated as Exhibit 1?
Yes, I did.
Is it true and correct to the best of your knowledge?
Yes, it is.
If I were to ask you the same questions today, would you give the same answers?
Yes, I would. There are minor typos that have no bearing on the substance of my testimony.
Mr. Gaume, did you prepare rebuttal technical testimony and exhibits that New Energy Economy has labeled Exhibit number 4?
Yes, I did.
If I were to ask you the same questions that appear in New Energy Economy Exhibit 4 today, would you give the same answers?
Yes, I would.
Did you prepare surrebuttal technical testimony and exhibits that New Energy Economy has designated as Exhibit 18?
Yes, I did.
If I were to ask you those questions today that appear in New Energy Economy Exhibit 18, would you give the same answers?
Yes, I would. My rebuttal contains Exhibit NG21, Revised Rule 20.6.8 regarding ground and surface water protection, produced water. Why is this important? Because this revised rule submitted for your consideration is consistent with science, law, and the protection of human health, the environment, and New Mexico's rivers and streams.
Please provide a brief summary of your professional and educational experience.
I'm a product of water workforce development, of a water workforce development program for implementation of the 1972 Clean Water Act, sponsored by the U.S. Environmental Protection Agency at New Mexico State University in the 1970s. I earned a Master of Science degree in civil engineering after completing a Bachelor of Science degree in electrical engineering. I began my New Mexico water engineering career in 1978. All my New Mexico employment has required professional engineering licensure. After 2 years as a supervisory technical maintenance engineer, I was promoted to be manager of Albuquerque's wastewater treatment plants and was responsible for the 1972 Clean Water Act, NPDES, permit compliance and reporting. Later, as technical services manager for the Albuquerque drinking water utility, I was responsible for the city's compliance with the 1974 Safe Drinking Water Act. I served as the city's water resources manager from 1990 to 1997, where, after developing scientific research and data, I led the process to formal adoption and funding of an adaptive strategy for water sustainability. I also co-led the preparation and city-county adoption of the Albuquerque-Bernalillo County Groundwater Protection Policy and Action Plan, which remains in force today. My top assigned priority as director of the New Mexico Interstate Stream Commission, 1997 to 2002, was to find a permanent solution to New Mexico's Pecos River Compact compliance with the United States Supreme Court decree. The successful is codified at 72-1-2.4, passed in 2002. From 2003 to 2006, I worked under contract with the New Mexico Office of the State Engineer or its counsel to conceive, plan, and draft complex regulations for the Active Water Resources Management Program, codified at 19.25.13 in MAC, parts 1 through 50. My qualifications are fully explained in Exhibit NG1.
Can you please provide an overview of your testimony?
In my expert opinion, the Water Quality Control Commission should deny the petitioner's proposed Part 8 because it is riddled with loopholes, contains no scientific standards to protect public health, and will allow demonstration and industrial projects for off-oil field waste reuse to proliferate without adequate oversight. Unequivocally, I agree with the Environment Department's intention to prohibit produced water discharge and deny state certification of federal permits that allow discharge. I am dismayed with and oppose authorization of demonstration and industrial projects in the Environment Department's water reuse rule. This is the most important aspect of my testimony. The Environment Department has admitted that there are no peer-reviewed scientific studies to undergird the allowance of the inevitable discharge of treated or untreated produced water due to unpermitted reuse off the oil field. Forbidding discharge, but allowing reuse without permits or regulations as the law requires, is not only logically inconsistent, it threatens public health and welfare and the environment. Adequate ground and surface water quality regulations to protect the public health of New Mexicans and our environment require no discharge or reuse of treated or untreated fluid, oil, and gas waste, without exception, unless and until the scientific research and feasibility assessments described in the professional peer-reviewed expert report entitled Groundwater Protection Council Produced Water Report, Current Practices and Research Needs. Regulations, current practices, and research needs, until that report's protocols have been followed. This report, which is included in my direct testimony as Exhibit in G4, is crucial. The Environment Department and the consortium committed in 2019, and again in 2021, and again in 2022 to be guided by this framework going forward. Mike Hightower said the consortium would use this framework. The Environment Department continues to insist, but the consortium continues to ignore the logical, well-crafted protocols in the report's Module 3. The Groundwater Protection Council is a national group of state water quality protection regulators, like the Environment Department and the Oil Conservation Division's Class II disposal well regulators. The Groundwater Protection Council in 2019 published its rigorous framework for the orderly planned creation of science-based evidence for a particular case, such as off-oil field reuse of Permian Basin produced water. It was written to inform produced water regulators that protect human health and the environment. It is excellent and wholly applicable to structure a real program of Permian Basin fracking waste reuse research to guide you as regulators.
Can you please summarize your objections to the rule as currently written?
My most important concerns can be summarized as follows. Commissioner Brankard schooled me in the law. Any oil and gas fluid waste use off the oil field requires a permit. The rule fails to meet statutory guidelines because the legislature required a permit for any off oil field use of produced water. Plain language of the statute is clear, and it was written to protect human health and the environment. 2, the rule inappropriately conflates highly different classes of wastewaters under a single rule without substantive content. The Environment Department's rule and testimony lumps reuse of municipal wastewater with reuse of fluid, oil, and gas waste. Proper regulation would not muddle them. As Amy Hardberger, a professor of water law and policy at Texas Tech University, recently said, more research and review is needed to determine appropriate uses of produced water. She said, the Clean Water Act never contemplated this water going into rivers and streams. Hardberger points out that many of the constituents in produced water are difficult or costly to test for and do not have established EPA toxicity standards. These are numerical values. These are numerical values measuring the risk presented by exposure to a chemical or a contaminant. He compares the EPA's list of standards for public water supplies, which include exposure guidelines for approximately 90 contaminants, with the over 1,100 chemicals that have been found in produced water. And she warned that the science on public safety shouldn't be rushed to find a quick fix for produced water disposal. What's driving the train on this is not water shortage and the potential of an additional water supply, she said. What is really driving the change is that they are running out of disposal opportunity.
Hello.
That was a quotation. I share her assessment, and I believe this is what the evidence demonstrates. 3, the Water Quality Act requires that we cannot short-circuit scientific research and data that meets the standards of science by allowing disposal through reuse through demonstration projects or industrial projects. The Environment Department has already testified that the closed-loop demonstration projects or industrial projects will inevitably discharge. Therefore, this department admission means the Water Quality Control Commission must deny all reuse and handling off the oil field. If there is no science and no scientific standards that undergird the Environment Department's proposed regulation, the Water Quality Control Commission must not authorize the use or reuse.
What's your position about NMED's testimony?
There's a disconnect between the decisive testimony about the potential risks and harms from fluid oil and gas waste, as testified by Environment Department's technical experts in this rule. The rule authorizes the expansion or use off the oil field to produce water. Despite the Environment Department's and NMOGA's admission that fluid oil and gas waste contains radioactivity, PFAS chemicals, carcinogenic chemicals, and other extremely and highly toxic compounds, they want to allow industrial and demonstration projects reuse, including for water-intensive industries like hydrogen production, cooling for data farms, advanced chip manufacturing, for landscaping, rangeland rehabilitation, agriculture, and livestock production, environmental restoration, and more. That's how reuse is defined in the Environment Department's proposed rule. But you've heard the evidence. There is no known treatment at scale that addresses this level of combinations of dangerous toxicity. You, the Water Quality Control Commission regulators, are the protectors, the regulators. You stand in between public health and safety of New Mexico and protection of the environment and the oil and gas burgeoning waste problem. The oceans of waste oil and gas is creating, 4 million barrels a day, is their problem. You cannot allow them to dispose of it by spreading this toxic stuff all over New Mexico without the science to say it's safe. And it is not. It is my professional opinion that proposed Rule 20.6.8, as set forth in the Environment Department's amended petition, could cause irreparable harm to New Mexicans' public health, safety, and welfare, including potentially fatal radiation exposures to treatment plant workers and the risk of public exposure to highly toxic fracking additives and carcinogenic oil and gas compounds that the Environment Department's technical experts testified about. My SIR rebuttal, which is New Energy Economy Exhibit 18, contains my Exhibit 21, our proposed rule, which is necessary to protect human health, animal, and environmental risks. It prohibits discharge, prohibits state and federal permitting regarding discharge and reuse, prohibits use, and only authorizes those pilot projects and laboratory scale projects that pass regulatory muster. And that means during the permitting process for pilot projects and laboratory scale projects, after careful review, and only if the regulatory body determines that the benefits of research outweigh the risks, can the Environment Department issue such a research permit.
Is there anything else that you would like to say?
You've heard plenty of evidence that the fracking waste is highly toxic, carcinogenic, and causes severe negative health impacts like birth and genetic defects. When this so-called water reuse rule results in produced water reuse, and it will, if the Water Quality Control Commission fails to prohibit the discharge and reuse of liquid oil and gas waste, then New Mexicans will experience irreparable harm. Why do we propose such a rule? This is the most critical aspect of my testimony. And with all due respect, I know you have so much to read, but please read my SIR rebuttal and our proposed revised rule, which is consistent with the law and common sense protections for our health and welfare. I have grandchildren, like many of you.
Madam Hearing Officer, on behalf of New Energy Economy, I move admission of Exhibit 1, Exhibit 4, and Exhibit 18, respectively, the technical direct, rebuttal, and surrebuttal testimony of Mr. Norman Gom, and I tender him for cross-examination.
All right, thank you. Are there objections from any party as to the admission of the exhibits?
Madam Hearing Examiner, I would come over here. I'm just Jeff Wexler on behalf of NMOGA. I'm just hoping you'll clarify the rules for surrebuttal. It's not covered by the pre-hearing order, and we've heard some discussion about surrebuttal. I mean, typically the rule in state district courts and federal courts is that surrebuttal is only allowed if it's something that could not reasonably be anticipated. I'm wondering if that's the standard that applies, or if we're going to allow rebuttal more generally. I just need to understand the rules.
All right. So my general feeling about rebuttal is that it needs to be, I wouldn't hold it to such a strict standard that it could not possibly have been anticipated, but rather that it's genuine rebuttal. That is to say that it is genuinely offered in rebuttal to rebuttal, right? To rebut something on rebuttal.
Does that also include statements that were made as part of the hearing in the cross-examination process?
Yes.
Understood. With that, I have no objection. Thank you.
All right, thank you. Other objections from any party? Any exhibits 1, 4, and 18? No? And thank you, they're admitted. And let's start with the commissioners. I'm going to start with the commissioner on the platform. Commissioner Rosatos, do you have questions of Mr. Gom? He may have stepped away. I'll start at that side then. Commissioner Fry, do you have questions of Mr. Gom?
No questions.
Okay, Vice Chair Armstrong. Okay, Commissioner McWilliams. No, Commissioner Dominguez.
Thank you, Madam Hearing Officer. Good afternoon. Thank you for your testimony this afternoon. I'm going to paraphrase some of your testimony to make it a little more concise, and maybe you can help me understand how the commission will get to the point that it needs to be. So you basically indicated that demonstration projects should not be authorized because there's no standards for the produced water as it currently is. Is that a fair assessment?
Thank you, Commissioner, Madam Hearing Officer, Commissioner Dominguez. Thank you for that question, and I hope I can clarify that for you. Industrial projects, as defined in the Environment Department's rule, are a reuse, and they're not governed by anything but a notice of intent. Demonstration projects are defined to only include pilot projects, but the way pilot projects are defined, a pilot project could be a full-scale facility, like the waste isolation pilot plant. And so those uses are totally inappropriate before the science is available to regulate them. It is the job of the Produced Water Research Consortium to develop the science. That's why the Environment Department and the New Mexico State University formed the consortium. But you heard the testimony in May. There's no data in the database. There are no pilot projects worthy of the name that are underway. They're all yet to come. And so any reuse is problematic. Any reuse should be banned until the science is there and until this commission has regulated handling, storage, treatment, all of those aspects per the Water Quality Act, section 74.6-4P.
Okay, let me couch it in a different manner. So at least myself, I can't speak for the commission. So I'm trying to wrap my head around how we get from point A to point B. So it seems to be we've heard pretty much everybody testify that the science isn't there. So now we're left with what comes first, the chicken or the egg? How do we get to the science without research being done on the produced water? And how can we have research without there being it being used outside the oil and gas field. So there has to be a mechanism in place for research to be done. But what I'm hearing today is that that research can't be done because the science is not there.
Madam Hearing Officer, Commissioner Dominguez, that would be a true chicken and egg dilemma. But the proposal that I've made in my serve rebuttal testimony in the rule is that this commission needs to authorize research permits to do that science and do it appropriately if the plan for the science justifies the risk. And anybody could do the research that's qualified, but it needs to be public. It needs to meet scientific standards. The data need to be publicly available. There can't be any spills. And so if the department develops a research permit program and just puts a few rules in place, then that will have the force of law and that science will be conducted appropriately. Now, I have no opinion as to whether, well, I do have an opinion. The pilot project's results that I have reviewed from long ago were not done to a scientific standard, period.
Okay, to your point on research permits you referred to, I think even in the opening comments, and we've heard other parties refer to the Produced Water Act, that gives the commission or the department the authority to issue discharge permits for produced water. Does the Produced Water Act give this commission the authority to issue research projects in lieu of discharge permits?
I believe that the Produced Water Act and the changes that were made in House Bill 546 to the Water Quality Act give the commission broad authority to regulate all aspects of produced water reuse or use off of the oil field. If it's in the oil field, it's under the jurisdiction of the Oil Conservation Division. If the test is done on a disposal well pad or right next to it, there's not much risk to that compared to the thousands and thousands of spills that have occurred in the Permian Basin. But bringing that waste outside of the oil patch to do research requires you to regulate it. Regulate the handling, storage, and treatment for the disposition. And there's other verbs in there too, or actions. I hope that explains it to you, Commissioner Dominguez.
And I realize it may not be in your testimony, but you just referred to the Produced Water Act. Could you lead me to where in the Produced Water Act it gives the commission the authority to issue something for research purposes?
The words research permits do not appear in the Produced Water Act. There is a mandate that the commission permit. And would you like me to look up the language and read it to you? It's something like the handling, storage. Again, I don't remember all the verbs. The point is that the authority is very broad, and it's standalone. It's not standalone, but it was provided. It was delegated to the Water Quality Control Commission to protect public health and the environment. Science is encouraged It just needs to be worthwhile science. And there needs to be care that the oil and gas industry does not typically use to assure against discharges and spills, even in research. I mean, I remember a comment from Commissioner Fry that she was concerned about what's in the produced water from the perspective of laboratory workers' safety. You know, it needs to be disclosed.
Thank you, Mr. I appreciate your comments. I'm not for sure that you've given me what would help me wrap my head around it, but Madam Hearing Officer, and as to not drag things out for multiple weeks on end, I'll stop at that point.
All right, thank you, Commissioner Dominguez. Chair Thompson.
Thank you. Thank you, Mr. Gom, for your testimony, both the oral testimony and the written testimony, especially the written testimony is quite exhaustive. You and other witnesses have brought up the statement that over 1,100 compounds have been detected in produced water. How many compounds, do you know how many compounds have been detected in produced water from New Mexico?
Mr. Chairman, that is an excellent question. I was a member of the New Mexico Produced Water Research Consortium's Technical Research Steering Committee when it was formed. And I determined that their process was not scientific. They organized, you asked me how many. What I'm saying is the Produced Water Research Consortium over 5 years should have had that list out and published by now, but they have not. I understand that maybe 400 have been detected, but I have not seen that data.
The New Energy Economy submitted a motion to request testimony of Peju. I suspect you probably were not part of it. Were you part of that motion?
Mr. Chairman, I was not.
That motion included a paper by the research group at New Mexico State. It's a referee journal article. It's reports on a very exhaustive analytical study to determine what compounds, and it was, in my opinion, a very impressive piece of work. And they had detected something about 200, I don't remember the numbers, 220 or something like that compounds, nowhere near 1,100. So the continued statement that 1,100 compounds could be in it is not based on New Mexico data. Let me follow it up. How many compounds might there be in municipal wastewater? More than or less than 1,100?
Oh, I suspect that there are lots of compounds. There's a difference, though. There's a huge difference. Municipal wastewater is very well understood. There's a huge body of data behind, for example, the BOD test that allows it to substitute for individual analyses. Where is the huge body of data from the Produced Water Research Consortium that lists the contaminants we need to be concerned about? We heard testimony that from Mr. Hightower that it's easy to get the quantity information of produced water out of operators, But operators consider the quality of their produced water to be a trade secret, a proprietary to their business. They have the data, they have the knowledge, let them put it forward instead of talking about what really are unknown unknowns.
So you talked about the reporting, and I assume you're talking about the chemicals they use for fracking.
I'm talking about that. I'm talking about the transformation products that they discover after they do, bench scale tests that weren't there before. I'm talking about a complete characterization of produced water, which certainly the industry has, but you do not, and neither does the public.
I can't challenge that. But then we cut to the chase, and it really, does it matter what is in the source water? And the regulations that we have at present deal with the regulations of the water that is being used, whether it's irrigation, potable water, or industrial use. So does the source, the poor characterization of the source, as you believe it is poorly characterized, is that as important as what the criteria for the water when it is finally used?
I think that they're equally important. If you don't have a characterization of a waste, I have training, you have much more than I. As a water and wastewater engineer, you have to know what's in a waste to treat it, or you have to have done previously enough research that you know that if you measure if you do one particular test, it covers a range of contaminants. But that research is not done, or if it is, it's not public.
So I don't know what.
Yes, the source matters, Mr. Chairman. I forgot your question. The source very much matters.
So M abstracts list, I don't know, somewhere between 500,000 and 1 million different compounds. And in the Safe Drinking Water Act, we regulate about 100, and there's another couple hundred that are required to be reported, like PFAS compounds. Are you suggesting that there are other constituents in treated wastewater that we should be analyzing for?
I'm sorry, Chairman Thompson, I didn't understand your question. Yeah, are you asking about produced water or wastewater?
Thank you. I appreciate the clarification. That's important. I'm talking about treated produced water. Are there constituents that are not regulated that we should be measuring in the treated produced water?
Yes.
Can you give me one example?
The compounds that we don't even know what they are.
Pretty vague.
Well, it is vague. That was vague. And no, I wasn't prepared to come to answer that question with specificity. But if there, this is why the source is so important. What's in the fracking additives? The Environment Department testified that they're going to keep coming out. And I believe from my professional training that that is the case. They don't all come out in the first flush. You never know when those chemicals are going to come out. Industry needs to tell us what's in there. And that was the Environment Department's testimony that that's essential. And I can't cite that for you. If I had stayed in the Produced Water Research Consortium and given 5 years of my life to whatever they've been doing, I probably still couldn't answer that question.
And I acknowledge those are tough questions. So there has been a lot of concern about the chemicals that are added during the fracking process. Are those they may be proprietary, but are they required to be reported to OCD?
No.
Okay. Not the answer I was expecting, but that's okay. I'll ask it from other people. My last.
May I explain?
I'm sorry?
May I?
Please.
They report to Frac Focus. Frac Focus makes allowances for proprietary chemicals, proprietary compounds. So you know the class chemicals, you know that an industrial surfactant has been used. You don't know what it is. You know that biocides have been used, but maybe they're a proprietary formulation. So no, you don't know.
Okay, that's a much more complete answer, and I appreciate that. Thank you. Thank you. Yeah. My last line of questioning is your concern about releases from pilot testing, and you're pointing out the waste isolation pilot plant. That's a pretty powerful argument. But if perhaps the commission was to put some upper limit on the scale of a pilot plant, let's say 5 gallons a minute, 10 gallons a minute, 2,000 gallons a day, or something like that, wouldn't it be possible to run a pilot test for a long period of time, 6 months or a year or something like that, and return the treated water back to the oil and gas industry? Perhaps return it to their ponds or something like that. So my question is, could the commission modify the regs to allow pilot testing and prevent the constituents, the treated water and the concentrate from the treatment process, prevent that from leaving the industry?
Yes. That would be a good thing. Pilot plants should not have, pilot plants have to, let me back up, sorry. A pilot plant to investigate treatability of a particular waste needs to draw on laboratory scale analyses. It is the next size up. Not only does it need to be run with higher volumes like gallons per minute, as you mentioned, it must be conducted over long durations. And if it's done properly, it need not discharge. And it all could be returned. But you can't say to the oil and gas industry, we trust you, because they have shown that they can't be trusted to contain their waste in their pipes, in their storage tanks, in their pits, their trucks. Everything leaks.
So if the commission decided to put some upper limit of scale on the pilot plant and include, the qualification, there be no discharge, no leaks escaping the facility, the waste was returned back to within the confines of the treatment facility or the disposal facility, would that meet your approval? Yeah.
Absolutely.
Again, I'm asking
Absolutely, that would meet with my approval. That is what needs to be done. There needs to be a permit to go with that. There needs to be something that has the rules, that is enforceable. You've heard the environment testify that if they allow these, they have no capacity to act on anything other than a whistleblower or a citizen complaint. And if the facilities are on private property with the public excluded, there aren't going to be any citizens that have any specifics. And will there be a whistleblower? That's not enough. There has to be capacity to verify, to inspect, to check.
Thank you.
Appreciate it.
Thank you,
Okay.
Mr. Chairman.
Thank you, Mr. Chair. Commissioner Bayless. All right, thank you. Commissioner Brankard.
Thank you. Thank you, Mr. Goff. Thank you for your brief discussion of your written testimony. I appreciate that. I'm trying to get my head around this new proposed permit that you've thrown at us here. And I guess I'll just ask a simple question. From what I understand from your conversation, Commissioner Dominguez, and which was going to be my first question, is that this is a permit authorized under the Produced Water Act. Right, that's where the authorization for this permit occurs.
Mr. Brankard, I would say that the authorization is in both the Produced Water Act, which is only 5 sections, and I think we're talking 70-13-4D. And then there's changes to the Water Quality Act that were both made in the Produced Water Act and then separately in other sections of House Bill 546, 2019.
Okay. All right. So in looking at your rule, if I am a next door neighbor to a pilot project, A, how would I get notice of a permit application? And B, if I was not happy with that permit, how would I appeal it?
Madam Hearing Officer, Commissioner Brankard, I think that is up for the Water Quality Control Commission to decide in writing the rules for getting such a permit.
So you'll give us this permit concept, and then we're going to have to expand it to cover all the procedural requirements, appeal requirements, etc.
Mr. Brankard, I believe that's your job.
Well, we don't normally write regulations. We have other people propose them to us. But anyway, thank you. That's all I have.
Thank you, Commissioner Vihel.
And none at this time.
All right, and Commissioner Rosatos, do you have any questions? You have stepped away.
No,
right,
I haven't.
Oh,
Thank you,
all right,
Madam
thank you.
Examiner. No questions on my end. I appreciate it.
Thank you. All right, let's go to Namoga. Mr. Wexler. Oh, you know what? Actually, I'm sorry. We started at 1. I'm thinking maybe a short break would be good. Yes? All right. Let's take 15 minutes. Let's come back from the break, please. Mr. Wexler, my apologies. I have a request. Please stay where you are. I have a request from a commissioner to loop back to commission questions. Commissioner Fry.
Okay, thank you. So you brought up BOD testing for wastewater. I think it was Mr. Hightower, Dr. Hightower, sorry, and possibly Namoga. I don't quite remember all the parties that brought up the wet testing for produced water. What is your opinion of that?
Madam Hearing Officer, Commissioner Fry, I'm not an expert in wet effluent testing. When I was manager of the Albuquerque wastewater treatment plants, we had to do wet effluent testing as part of our compliance with our NPDES permit. And I understand there are many kinds, but I think some of the principal concerns here are with mutagenic, heterogenic compounds that have effects that play out over generations. You know, those materials have to be gone from the water. There can't be any standards for those. And you know, I don't think it's my opinion that the wet effluent testing cannot deal comprehensively with chronic exposure and bioaccumulation. And I would add that Mr. Hightower in 2019 said bioaccumulation and toxicity were his primary concerns.
Okay, and then this idea of a research permit, I guess something that came to mind, we were just discussing, what's the difference between a research permit and a regular permit? What is the cost? How do researchers at universities handle that cost? So I'm trying to wrap my brain around that concept. You know, can you think of some instances where it's been done successfully?
Commissioner Fry, I do not know of instances where a research permit for produced water has been required. I think we're at the forefront of things. This waste is so different and so complex and so toxic, you know, that the rules for other kinds of waste may not apply here. My opinion that they don't. This rule that the Environment Department put before you only had an NOI with the sparsest of details, and really no way for the Environment Department to say no if all of those were superficially met in the notice of intent that was filed. A permit application would be more rigorous. It would need to be designed. You don't see the permits in the rules. You know, they're developed subsequently by staff. I know that staff has tremendous capacity constraints because they've not been funded. But that should not short circuit the requirement for the research to inform the regulators. I would add one other point. The independent review committee that the NMED and NMSU Board of Regents agreement signed November 10th, 2022, calls for rigorous research. It calls for standards to be followed. And it says that, I'm sorry, I think I just misspoke. Let me back up. What that report says is that the oil and gas industry has all the expertise needed to develop the treatment processes, that it's the consortium's job to show that reuse is safe. And when they do their job to show that research is safe, you will have the information you need to develop the standards and the regulation from those standards. In the meantime, you can make up a research permit. Again, where else has this been done? To say that if you're going to take this toxic stuff off the oil field for a pilot plant or any other research, there needs to be a valid research purpose to justify the risk. And it needs to be permitted, so it's a legal requirement, not just a paper requirement.
So when I asked, thank you, when I asked about the research permits, I was talking more generally. When can you give an example of when a research permit has been given, not just in produced water?
I can't, because I think this is, I mean, where else have we encountered an extremely high volume, extremely complex, extremely hazardous waste that needs to be researched? Well, and not only research, but research for discharge and reuse. I mean, it's a whole different game than anything else I'm aware of that's ever been done in New Mexico or the United States with regard to a really complex waste. You know, usually it's waste treatment for discharge to a river or something. That's the standard. Treatment of a hazardous waste for reuse is a brand new concept. And so the research permit just needs to provide the basics. So as I said before, the benefits outweigh the risks. Does a laboratory need a research permit? Well, you mentioned, I mean, laboratory waste goes down sinks all the time. And, you know, I don't know what processes are used in laboratories now. I don't know how researchers protect themselves. But the permit should show that the research is being done for a particular purpose in a laboratory that is suitable for this kind of research, and that they know the constraints of disposal of the residuals from the research.
So just to make sure I understand you correctly, you're saying you don't know of any instance where there's been a research permit.
I said that. I also said I'm unaware of another circumstance like this in history.
Thank you. Thank you, Madam Hearing Officer.
All right, thank you, Commissioner Fry. Anyone else on the dais? No. All right, Mr. Wexler.
Thank you. Good afternoon, Mr. Gum.
Good afternoon, Mr.
I want to start with just a few questions about your background, and then I have just a small number of questions about your testimony generally, and then a little bit about your rebuttal, which came to light just today. So your qualifications are on page 1 and 2 of your direct, and you attached your CV. Is that right?
I don't have a CV. Mr. Wexler, I attached my resume. I had to make one for this hearing. My most recent one was 10 years old.
Fair enough. On page 2, lines 5 to 6 of your direct testimony, you acknowledge that you've never appeared before the Water Quality Control Commission. Is that right?
That's correct.
Have you ever sat as a commissioner on the WQCC?
I didn't understand you.
Have you ever sat as a commissioner on the Water Quality Control Commission?
No.
Have you ever?
I'm sorry, did you ask me if I ever attended a hearing?
No, if you were a commissioner ever.
No.
Did you ever act on behalf of an applicant for a discharge permit or any other permit before the Water Quality Control Commission?
Never.
Am I correct? You've never been a researcher in the area of the chemical makeup or the constituents of produced water?
You're correct.
Am I correct that you've never been a researcher on the methods for treating produced water?
A researcher? No.
You mentioned you sat on the consortium, or you participated in the consortium. How long was that?
A little over a year.
Other than that position, have you ever had a professional position that focused on produced water?
No.
On page 3, line 18, you mentioned, and actually throughout your testimony, you talk about your expert opinion. What fields do you consider yourself to be an expert in?
Mr. Wexler, I am an expert in getting things done properly, according to science and according to economics, the right way.
I'm afraid I'm going to have to ask you for some scientific field that's generally recognized. I'm not sure getting things done is a...
I'm an expert, as indicated by my master's degree in civil engineering in water and wastewater treatment. I am an expert in New Mexico's water resources and our dire situation with respect to climate change, making our water go away. I've never held a job that didn't require my licensure, which means I apply professional standards to everything I do, Mr. Wexler. And my expertise in engineering science is recognized by my professional engineering license.
And if it sounded like I was doubting your qualifications for the work that you did, I'm not. However, there are specific areas of expertise that might be more applicable here than in others. In other areas. Is it fair to say that most of your professional work has been in the area of water resources?
Yes.
Now, as the director of the ISC, you had responsibility for water planning. Is that correct?
Yes.
Do you have your testimony before you? This is NEE Exhibit 1. And I'm interested in going to what is PDF page 112. This is,
You're looking at my direct testimony, what page?
I am. Well, it's one of the exhibits to your testimony. So this is going to be, apologize, I just had a file get corrupted. So I'm using somebody else's folder here. This is the NG4. And of that document, it's page 27.
Page 27?
Yes, please. There's a heading in the second column that says produced water as part of the state water planning process. That's why I asked about the planning that you had done.
Go ahead.
You see under that heading, it says, as states begin evaluating long-term water needs, water planning plays an important role. Most states and regions are experiencing water shortages due to drought, population shifts, and increased usage. You see that?
Yes.
Now, based on your experience, New Mexico has experienced water shortages due to drought. Is that right?
New Mexico has experienced water shortages because it is a desert.
New Mexico has also experienced population growth and population shifts. Would you agree with that?
Yes.
And New Mexico has experienced increased water shortage.
Didn't hear your full statement.
Will you agree with me that New Mexico has experienced increased water shortage?
Yes.
Page 3, lines 21 to page 4, line 3 of your direct testimony, NEE Exhibit 1.
I need to keep up with you. What lines?
Yes, it's page 3, line 21 through page 4, line 3. I believe this is your executive summary.
Yes.
Here you suggest that NMED, quote, said a simple no discharge rule for produced water, whether treated or not, would be promulgated in 2022. You see that?
Yes.
And you cite to what is your NG2 slide 11.
Yes.
Sorry, what? 2. Yeah, it's hard to get this microphone just right. Is that better? NG2 and 1, 2. So because I think it's important to understand the development of the rule, I want to take a look at your citation. So this is, again, it's NG2 slide 11. It's also PDF page 57 if you prefer that route. Let me know when you're there.
I have it.
And this is the presentation that you're referring to, is that right?
Correct.
And then I believe you refer to slide 11. So if you don't mind going to slide 11, it has a heading at the top that says NMED produced water timeline. Timeline, correct?
Yes.
And then if you look at the 4th bullet point, this is in the year 2022. And the last phrase there, you with me? It says NMED phase 1 rulemaking.
Yes.
And I think this is what you're referring to and citing to in your testimony. Is that right?
I believe that is what I cited to.
And here, just to read it, it says prohibit untreated produced water use outside of the oil and natural gas industry. Did I read that right?
You did.
Let me ask you this. I'm not aware of any party to this proceeding, including NMOGA, that is currently advocating for untreated produced water to be allowed to be discharged. Do you agree with me?
Yes.
All right, page 4, lines 5 through 9. Now, you're relying heavily on the report you identified in exhibit NG4, is that right?
Page 4.
Correct, lines 5 through 9. And I think there's other parts of your testimony. Yeah, so is it fair to say you're relying pretty heavily on that exhibit, NG4?
Yes.
In fact, I think you say at one point that it's necessary to follow what you call module 3, right?
Yes.
And just a couple quick things to note about this report. So if you go to there, let me just find the page since you're using a paper copy. It's PDF page 79. That's the cover. That's exhibit NG4.
PDF page 79.
Correct. And hopefully that takes you to the cover page of this report.
I have a cover page.
Yeah, so just to confirm, this is that document that you had relied upon, correct?
Yes.
And then if you look at the next page, the acknowledgements, just want to point out in the second column there, we can see the name Rick McCurdy. You see that?
I do.
You understand Mr. McCurdy will be testifying later in this proceeding?
Yes.
And then another thing about this report, if you go to the next page, this is the letter from the executive director to the reader, and it's dated June 2019. You see that?
You?
And you recognize that's approximately 5 years ago, right? Is that right? And are you aware that there has been significant research and work in the field of treatment and reuse of produced water since 2019?
Yes, I'm also aware that there is no data in the Produced Water Research Consortium's database.
I'm sorry, I couldn't quite hear you.
I'm aware there's been significant research. I'm not aware that that research is available to these regulators today.
The regulators don't have the ability to locate the research. Is that your testimony?
I'm saying that no research has come forward in this hearing.
Your testimony is there's no research that has come forward since 2019 as
No,
part of
I'm
this hearing.
saying that in this hearing, we have no results of pilot tests. We have no characterization of produced water. We don't have the beginnings.
Have you reviewed all of the exhibits that have been submitted either by the Environment Department or NMOGA?
I have reviewed the Environment Departments, and I've looked at many of the NMOGA submittals, but I can't say that I've reviewed all the exhibits.
And if I understood this, part of your testimony, it's also your testimony that none of the exhibits, none of the evidence filed with the commission have to do with those pilot projects. Is that right?
I'm saying that there's been lots of academic work by the researchers at New Mexico State University. Their research is not attributed to the consortium, but they are the consortium's experts. So they've done lots of research and brought information together. What we don't see are what I just mentioned, what is in the produced water, or the results of any scientifically conducted pilot scale testing.
Do you consider it important for the commission to be making a decision about these rules based on the latest and greatest research in science?
This commission has to make rules based on what's in the record.
And do you think it's important that the record contain the latest and greatest science?
I think the record, I think the NMED did a pretty good job of putting their information into the record, but it's not actionable information.
Did you attend that conference that took place a month and a half ago, the State of the Science of Produced Water or some such thing? You did not?
No.
Okay, on page 7 of the direct testimony, you start a section on statutory requirements. And I think in your rebuttal, you acknowledge that you're not an expert in statutory interpretation. Is that right?
What I said was that in my job as Interstate Stream Commission Director, I had to interpret statutes to do my job. I am used to interpreting statutes. I also interpret statutes to give direction to my general counsel to do something that I believe the statute enables And if the general counsel agrees, that's what we do. I believe that statutes can be read narrowly or expansively.
Do you have before you your rebuttal exhibit?
Didn't hear you.
Do you have before you your rebuttal testimony?
I do.
It's NEE Exhibit 4, I believe. And if you can look, please, at page 25.
Yes, sir.
Lines 5, excuse me, 5 through 7, quote, I am not qualified to describe legal authority as an expert, but I consult the New Mexico statutes annotated and the New Mexico Administrative Code routinely in my professional work. That's your testimony, right?
It is.
Turning to the tables back in your direct testimony. So this is at page 9. And really, I want to ask you about a phrase that you repeat numerous times.
I have page 9.
Okay, in I believe it's the very first substantive row after the headings there, you say that, quote, no peer-reviewed scientific evidence currently justifies any reuse of the oil field. You see that?
I do not. Page 9 of my direct.
I believe so. Yeah, let me just double check. I have the right.
You need to give me a line number, please.
Okay, it should be part of the table. Yeah, the page wrong.
Oh,
yeah, it's
under reason. Yes.
Yeah, so under reason, right? You see where it says no peer-reviewed scientific evidence? You with me now?
Yes.
My question has to do with the sources that you rely on for that statement.
The law requires, I consulted the statutes. No peer-reviewed scientific evidence currently justifies any reuse. Well, the pilot testing, so-called pilot testing that's been performed by the consortium to date, is not scientific evidence. The results aren't even tabulated. Mr. Hightower testified he didn't even know when some of the research results would be submitted. The record in this hearing has demonstrated an absence of applicable science. To justify safe reuse. We've been over and over with that concern, and there is broad agreement. And I am aware of no data, and that's the justification for and for the unacceptable reporting of the pilot projects done to date. And we don't know that we're going to have good reporting out of the projects that are coming, because the consortium has no standards for the scientific work that is conducted under its purview.
You don't think those researchers are held to normal research standards?
When they operate in a trailer somewhere with no public oversight and they don't even measure the contaminants of concern, yeah, I'm concerned.
Have you reviewed the documents that were submitted as NMOGA exhibits 75 through 127? They're peer-reviewed papers.
No, I looked at some of them. Nobody, no.
Page 19 of lines 4 through 8 of your rebuttal testimony. This is NEE Exhibit 4.
Page
19.
Lines
4 through 8.
Yes.
And so here you're responding to testimony from NMED witness Jason Herman. And he, as you state there, he indicated that he's not aware of any discharge permit that was denied based on the source of the water. Are you aware of any discharge permit that has been denied based solely on the source of the water?
No.
A little bit further down on that same page, and here this is lines 10 through 13.
Yes.
And you indicate that just as I stated above and in my direct testimony, if NMED continues to characterize fluid oil and gas waste, so let me just pause there. I understand you to be using the term fluid oil and gas waste as a synonym for produced water. Is that right?
That's right. That was the title of the bill that was introduced in the New Mexico legislature, House Bill 546.
So you continue, let's see, continues to characterize fluid oil and gas waste as, quote, water, sow confusion and obfuscate the science, then NMED should be concerned that an appellate court might grant an appeal from the oil and gas industry from a NMED refusal to allow authorized treated produced water reuse. You see that?
I do.
Hey, can you explain what you're saying there more? I didn't follow.
Well, if you read the next few lines, you will follow.
Well, if you could please summarize, I'd appreciate it.
Okay. But if NMED applies the science, which
Well,
is clear.
I mean, I've read the words. I'm asking you to summarize because I don't quite understand.
Fluid oil and gas waste is a novel waste.
Not water.
It is not water. Just because the majority, if you make coffee in the morning, do you call it black water? No, you call it coffee.
But what percentage of coffee is water?
It doesn't matter. It's still coffee. Waste is waste. And if it's fluid, it's going to have water in it. That doesn't mean it's water. It means it's waste.
What percentage of produced water is water?
Well, if it's 20% salt and maybe a couple of percent of other things.
I'm sorry, did you say 20% salt?
10 to 20% salt.
What paper are you relying on for that figure?
I can't cite a particular paper unless you want me to know. I will look it up if you want me to, but it's all over the place in the record.
I don't think it's necessary. If you turn please to page 25 of your rebuttal. And here I'm looking at the Q&A. I think it starts lines 3 and continues for a while there.
Yes.
In lines 10 through 12, you cite the Produced Water Act. Let me just go and find my copy here. Yeah. So you cite the Produced Water Act for the concept that the commission shall adopt water quality standards for surface water, for surface and groundwaters of the state based on credible scientific data and other evidence appropriate under the Water Quality Act. You see that?
I did not say that.
That's not what your testimony says?
No, my testimony is the bill that included the Produced Water Act.
I see. I see. So let me just ask you more generally. Did you listen to the testimony of the Environment Department witnesses?
Yes.
Do you understand that the Environment Department is not requesting a water quality standard in this case?
I understand that the Environment Department doesn't have the data upon which to base a water quality standard.
So they're not proposing a water quality standard, right?
No.
and not relying on 7464D for their proposed rule.
7464D.
Objection to the form of the question. How does Mr. Gom know what NMED relied on to create its rule?
All right, Mr.
Well,
Wexler, would
that
you
was
read
why
that?
that was why I asked him if he was here for the department testimony,
Right.
to which he said yes. So if he doesn't know what they're relying on, he certainly can answer that.
Right, that's fine.
Would you
ahead,
please
Mr.
repeat the question?
My question is, do you understand whether or not the Environment Department is relying on 7464D for their proposed rule?
I don't know.
In your testimony, you cite to 7464 subsection E as in echo. And you note in lines 16 through 17 that, quote, regulations may specify a standard of performance. You see that?
Yes.
Do you understand that the Environment Department has indicated that it does not consider the proposed rules to propose a standard of performance?
Yes.
I want to turn a little bit to your testimony this morning, your rebuttal testimony, and a little bit about the notice of intent requirements for the demonstration industrial projects. Let me ask you first, are you familiar with the regulations that govern discharge permits?
Objection to the compound nature of the question and assumes a fact that's not in evidence.
I think my only question was, is he familiar with the regulations that govern discharge permits? That's not
Except that there was a whole bunch before that. If that's just the question, then that should be noted, please.
Okay, that'll just be the question.
Yes.
Have you ever applied for a discharge permit?
No.
Have you ever been the regulator or evaluator of a discharge permit?
I want to back up for a minute. When I was manager of the Albuquerque treatment plants, I was involved in getting discharge permits for the new facilities. I haven't otherwise been associated with a discharge permit professionally.
Are you aware that there is a provision within the regulations that allows NMED to determine that no discharge permit is required?
Yes.
If I understood your testimony earlier, you were talking about the Produced Water Act, which I'll just point out is NMED Exhibit 19. And if I understood your testimony correctly, you were referring us to section 70-13-4D as in dog. Is that right?
Yes.
Now, and you were pointing out, it was your testimony that a permit would be required from the department before using produced water. Is that right?
I believe the language of 70-4, so 70-13-4D is plain. A person shall obtain a permit before using the produced water, the recycled or treated water, or treated product, or any byproduct of the produced water.
Does the statute define using?
Does not.
The provision that of the proposed rule that governs demonstration projects or industrial projects, that shows up in 20.6.8.400B, as in boy.
Just for clarification, you're talking about NMED's rule?
I'm using NMED's rule at the moment, which is NMED Exhibit 175. But
that's
okay.
And there you can see they're talking about demonstration projects or industrial projects determined by the department not to require a discharge permit. You see that?
Can you tell me where?
Yeah, it's on page 5 of their exhibit. is again 20.6.8.400 B as in boy.
I apologize. I have a struggle reading. I had an eye operation since May. And
I hope it's doing okay. Are you able to read it?
yes,
And so I guess my question, I'm not clear on your testimony if it's just a semantic issue. Do you think that the commission could adopt rules, so different language here in this subsection B as in boy, that basically said the department can adopt permits for demonstration, for using produced water for demonstration or industrial project? I mean, that would address the issue that you were raising, right?
I didn't. Would you please?
Sure. If I
that?
understand your issue, it's what you're suggesting is somehow the language of the Produced Water Act, that provision that we looked at, requires permits for using water, and you think that the demonstration projects or industrial projects is using water, notwithstanding there's no definition, right?
Yes.
And so what I'm asking is, I mean, if you built into this subsection the provision that the department is authorized to issue a permit for demonstration projects or industrial projects that don't require a discharge, that would address the statutory issue you're identifying, correct?
It might address the statutory issue. It wouldn't address the practical issue. And that's what I'm an expert in, sir. To get things done, you have to have a complete system. So to say that the permit requires a no discharge and then not to have the presence to be able to verify that, or rules in law, means it's unenforceable, unenforced. And the oil and gas industry, as I've stated, has set its own record with regard to its handling of waste on the oil field.
Similarly, if you, and I'm going back to the regulations for discharge permits here, if you allowed discharge permits for treated produced water as was originally proposed, then the Environment Department would be authorized to grant a discharge permit, right?
What's the predicate of your sentence?
Yeah, we're still talking about demonstration projects and industrial projects. And if the rule adopted by the commission allowed discharge permits, that would address your issue that they're, about the permit is required for using produced water.
No, it would not.
Well, there'd be a permit, a discharge permit, right, for those ones that the department determined were appropriate.
There's no science to justify a discharge permit. That would be against the law.
So let me ask you this a little bit, because you had some discussion about like characterizing produced water. You indicated you're familiar with the discharge permit regulations. You understand that an applicant has the burden of characterizing the source water, the constituents, when they apply for a discharge permit.
Exactly.
And then the department has the ability to tell an applicant, you know what, we don't think you've provided enough information. We want you to go and characterize it more, right?
Yes.
Ultimately, the discharge permit has to satisfy existing water quality standards, right?
Existing water quality standards?
That's right. All water quality standards, applicable water quality standards.
The only ones it could satisfy would be existing.
We agree on that. And if the Environment Department determined, however, that those water quality standards weren't sufficient, they could always require additional permit conditions, right?
The Environment Department and NMSU Board of Regents entered into an agreement to create the consortium to provide the research for the Environment Department to as the basis for their writing of their regulations and their standards and their discharge permits. Until that bar has been satisfied of information in the record showing that it's safe, they cannot write a permit allowing discharge. It would be against the law.
So maybe I wasn't clear in my question. I'm just asking about the process for discharge permits, and I didn't mean to be referring to the consortium at all. So are you aware that in applying for a discharge permit as part of that process, the Environment Department can require additional permit conditions?
I believe so.
One last question about the demonstration projects, and that is, if the commission adopted your proposal, then there'd be no pathway for doing demonstration projects or industrial projects. Is that right?
Of course, there's a pathway. Do the science first. Put it in the record. Get standards, get regulations, apply.
So your
There is a path.
Your pathway would be adopt new regulations sometime later in the future.
Absolutely.
Under the existing rules passed by the commission, there would be no pathway for demonstration projects or industrial projects, right?
This is a brand new topic, Mr. Wexler.
Is that a yes?
Ask the question again, please.
Yeah, my question is, under your proposal, if the commission were to adopt it, setting aside some subsequent later regulations, under your proposal, there would be no pathway, no way for parties to engage in demonstration projects or industrial projects.
At this current time, no.
No further questions. Thank you.
All right, thank you, Mr. Wexler. Mr. Maxwell, do you have questions of Mr. Gahn?
Yes, Your Honor. My first question, earlier today, I believe during Chair Thompson's questioning, you had stated everything in the oil field leaks. Is that true?
Maybe not literally, but figuratively, it absolutely is true.
You agree you were being a little hyperbolic on that, correct?
Would you define hyperbolic?
Exaggerating.
Spills are illegal in the oil field now, Mr. Maxwell, and they occur daily in large volumes. I testified that spill control in the oil industry is voluntary. If people have, if operators have external pressure to clean up their act, they do it, and they have some results to show for it. Other people, it's a business expense. There's no enforcement, so they spill. I've looked extensively at the records of the Oil Conservation Division, all self-reported data from operators, and you find preventable spills and leaks of produced water are commonplace. For things like human error or overflow or corrosion, things that are, in my experience as a maintenance engineer, are caused by using the wrong materials of construction or not doing frequent enough maintenance, inspection, and replacement. And so, yes, figuratively, and the trucks in Carlsbad carrying produced water, leaking produced water onto the streets.
Do you have any exhibits that you're offering which back that statement up?
I believe in my exhibits. I need to think about that for a minute. A lot of time has elapsed since May, and I don't recall that I have that in an exhibit. It's absolutely part of my testimony.
Thank you. Your Honor, no further questions.
Thank you, Mr. Maxwell. Ms. Taylor, do you have questions? Mr. Cox?
No, ma'am.
Mr. Hightower.
Hopefully, Norm, this will be easier for you. I'm not a lawyer. You know that. I just have a few questions. You mentioned my name a number of times. So I think part of the references are absolutely true. I agree on many of those. Some of them, I think maybe they're slightly overstated. And so I'm just going to ask you a few questions if that's all right. First of all, I want to talk about the Groundwater Protection Council report. I think some people haven't read it. It's a very good report. Came out in 2019. It was by industry and some of the national laboratories and the EPA. In that section, section 4, page 4 of that report, page 127, it talks about risk and toxicology analysis. Risk and toxicology analysis of produced water. And I think it was one of the things that Norm was mentioning, that it provides in that report on page 129 and 130 a risk and toxicology approach for looking at the safe reuse of produced water. You have that on your computer because I saw it on your screen before, so I know you have the report.
Yes, you said page 27?
127.
120.
Yeah. And then right below that, page 129, flow diagram.
Diagram?
Okay. And you mentioned that it would have been, nice if maybe the consortium had taken that flow diagram recommendations by the Groundwater Protection Council and implemented that. Do you know that the consortium in 2021 took that flow diagram and is implementing all those elements of that flow diagram currently?
Madam Hearing Officer, Mr. Hightower, thank you for that question. I was referring more to Module 3 and the step-by-step procedures that it lays out. I was not aware that the Produced Water Research Consortium has adopted this flow diagram.
And that flow diagram has been published now in peer-reviewed journal as the approach to use for produced water treatment nationally. Did you?
Was there a question?
No. Did you know that? Okay. All right. So point is, I agree with you on the Groundwater Protection Council. Toxicology and risk is a very big deal. And I do agree that you quoted me right when I said that bioaccumulation and toxicology, I think, are two of the biggest issues. And one of the things associated with this is not only risk and toxicology testing, but bait transport modeling. Very important to address some of the issues that have been brought up today about soil contamination, groundwater contamination,
Mr.
surface
Hightower,
water contamination.
I'm
Okay.
sorry to interrupt you, but
Got to ask
this is
questions?
the time for questions.
Okay, I'll try. I'll try to get back to being a lawyer. I'm not very good at that, and we'll ask questions. Okay. So, a couple of things. It was asked by Mr. Webster if you attended the State of the Science Forum end of June in Las Cruces.
No.
That was put together by NMED in the state of New Mexico to do the state of the science on produced water treatment research and brackish water treatment and research. That included University of New Mexico, New Mexico State, New Mexico Tech. So, have you seen the proceedings from that state of the science? At that state of the science, researchers from New Mexico State presented sets of information from about 20 different peer-reviewed technical articles.
Mr.
And
Hightower.
have you seen any of those? I'm asking.
Okay.
Okay, I was getting into that.
All right.
Have you read any of those technical papers by any chance?
Read the ones that are in my exhibit.
Okay. Talking about produced water in general, have you had a chance to read any of the EPA reports done in the late 2018 through 2020?
I'm not sure what reports you're referring to.
The one that I think is very important is EPA 821-519 came out in May of 2020. It gives an overview of produced water quality, May 2020.
Title of it?
Don't have the title of it right in my fingertips. Okay. That gives an overview of produced water nationwide.
Madam Hearing Officer, I've tried to be extraordinarily patient, and I'm so sorry, but I believe that Mr. Hightower is testifying repeatedly, and so I would object to any of these kinds of further questioning going forward.
Yeah, Mr. Hightower, the bulk of what you've been saying is testimony rather than questioning.
So what I was trying to get to is that repeatedly, Mr. Gom has mentioned that there's no credible science. I'm asking about the science that I'm aware of, and if he's had a chance to review those reports previously.
So that's a legitimate question. I think he said he didn't go to the conference.
He said he didn't read some of the EPA documents, so that answers some of those questions.
Objection to that commentary. Mr. Hightower couldn't even name the title of it. So how could he know how could Mr. Gum know what he's talking about?
Yeah.
I gave him the reference number, but that's okay. I'll move on.
Please.
Okay. I think Chairman Thompson asked about the difference between treated produced water and produced water. And you've mentioned multiple times in your presentation today the issue about risk management and risk reduction. So the question I have is, from a risk perspective, would you believe that treated produced water would be lower risk than raw produced water?
It depends on how you define treatment.
Okay, the level of treatment, quality of treatment. Okay.
Clean brine
is still a
not
brine.
Clean.
It's still a brine. Okay.
Clean. Clean brine is not clean with respect to toxic contaminants.
All I said was he's correct. Clean brine is still a brine, which is hazardous by itself. Okay. So if you look at trying to reduce risk, you do believe that treatment and doing adequate treatment and the right kinds of treatment are the way to reduce those risks and to try to make sure that the water that could be used would be safe for the public.
Absolutely. And I say absolutely because of the qualifiers that you use in your question.
Right. And I use those intentionally. Okay. So I think we agree on that. And you have to treat it. You have to treat it right. Okay. So I'm getting to one of the things that I think that has been a contention today, and I want to get your opinion on it, is looking at bench scale and pilot scale. And the comment about having permits for those. Under our existing interaction with NMED, we have projects and bench scale projects that are presented to NMED, and they look at those from a risk management perspective. And in those cases, what we see is, in my opinion, is a permit to do the project.
Objection. Mr. Hightower's opinions cannot be part of these questions. Cannot be part of these questions.
Okay.
That's not trying to cross-examination. I'm sorry.
All right.
I've
So,
just-
Mr. Hightower, I do want to pull the legitimate question out of your colloquy there. Tell me the punchline, if you will. What's the punchline question?
So under the current permitting, permitting maybe is not the correct term. The current requirements for bench scale testing is to make sure that the person who does the testing, and when they do the testing, they take the produced water, they get a treated produced water and concentrate. It allows us to look at the treated produced water and the quality. They then require us to recombine those two waters back to the produced water. And then we have to handle it for OCD requirements. We use certified oil field haulers. We dispose of it in certified saltwater disposal wells. So from that perspective, their process is not a discharge of any water. It's a recombining, and then we discharge it under OCD requirements. In the bench scale, that's the process. In the pilot scale, that's the same process, is that water is treated, the two streams brought together, recombined, and then handled through typical OCD produced water requirements. Under that scenario, the way I see pilot testing and bench scale testing is that we're not discharging, we're using OCD permitted requirements. Is that something within your discussions and your suggestions that would be appropriate? Is that appropriate?
Objection, compound, full of opinion, assumes facts not in evidence, interchanges legal concepts without any basis.
Okay. So I understand it was compound. Let me get though to Mr. Grom. Mr. Grom, I was able to follow it myself. Mr. Grom, were you able to follow that? And do you have an answer? You don't have to have an answer, but do you have an answer?
I would ask that a simple question be asked of me that I can answer.
Okay. So
all right,
we're trying to get to the nugget.
I understand. So under the current efforts with NMED, or first of all, bench scale testing, if we were to take produced water, treat it into two streams, test one stream, recombine it, and then dispose of it within a saltwater disposal well, would that fit under your requirements or your suggestion as being equivalent to a permit?
Madam Hearing Officer, Mr. Hightower, it's not equivalent to a permit. A permit has disclosure. It's public.
Notice of intent public?
You have to let him answer.
All right. Yes,
And this has to be, I mean, as I said, this is a novel waste. People deserve to know what is going on with industrial projects and demonstration projects, which are not constrained by volume or anything else. And so this, in my view, is a backdoor way. Now, the kind of thing that you described, which I agree with, you know, it's proper that the Environment Department is doing this, but it ought to be public, not private. It ought to be a requirement, not an opinion that's given by one person and may be different in the next instance. There needs to be structure.
So you know,
but the whole idea of properly doing pilot tests and bench scale tests in a safe manner is essential.
but can you say that that process that they use currently does not meet your requirements?
I don't know what their process is.
I think that they're coming up next. We'll probably find out. Okay. I was going to ask the same question for the larger scale pilot projects. I agree with you that they're generally larger scale, higher volumes, longer durations. We have the same process with NMED that we have with the bench scale. We can recombine the streams and dispose of that. So we'll talk about, so the same question with that is it appropriate? Would it meet your requirements as you write it? And we'll probably have the same answers. So
For larger pilot projects, it is absolutely not appropriate. A permit is mandated by the law with no interpretation required. And the permits have to be based on, they have to come out of regulations that are based on standards. I mean, you're a civil engineer, you understand how things have to flow.
understand, but I think the rules are, it's about disposal. And in this case, the disposal is within the oil and gas. It's not outside oil and gas.
That's correct. But the rule is aiming for, or maybe I should say the industry is aiming for disposal by reuse.
Understand, but that's not the way that I think the laws that you have suggested were written, but that's my opinion. Okay. I don't think I have anything else, but I appreciate your time, Norm. Thank you.
Thank you, Mr. Hightower. Mr. Davis? Thank you. Ms. Fox? All right.
Good afternoon, Mr. Gom. During the questions from the chair, I believe he was discussing NMED Exhibit 140 entitled Characterization of Produced Water and Surrounding Surface Water in the Permian Basin, the United States. Article published in 2022, which is NMED Exhibit 140. Are you familiar with that article? Dr. Hu, in his direct testimony, discussed that exhibit, and I'm going to paraphrase some from his testimony, his direct testimony, starting at page 10. He says the majority of produced water samples originating from the Permian Basin, as documented by USGS database, were collected prior to 2002. Specifically, out of the 114,943 data sets in that database, only around 3,800 are associated with the Permian Basin, and these samples mostly come from conventional wells. However, out of those 3,800 data sets, only 39 samples collected in 2016 are included in the database, providing exceptionally limited information on inorganic bulk water quality measures, anions, and metals. Furthermore, there's a lack of data concerning organic contents and norm in produced water. A research team from New Mexico State University conducted a comprehensive quantitative analysis, that is, any references NMED Exhibit 140, targeting 309 constituents within produced water samples from 5 distinct locations within the Permian Basin. Their findings revealed detection of 91 analytes, while 218 analytes remain undetected. Although informative, this sample design limits what can be said about produced water characterization in the Permian Basin. And my question to you is, do you agree with Dr. Hu's characterization of that article?
Do.
He goes on to say that the NMSU research team findings from unconventional wells, again referring to NMED Exhibit 140, in the Permian Basin, exhibited TDS concentrations, which were very high, and an array of constituents, including mineral salts, metals, oil and grease, VOCs, semi-VOCs, norm ammonia, and PFAS. Furthermore, he says, it is imperative to conduct non-target analysis to discern unknown chemicals in produced water. However, as of now, no results pertaining to non-target analyses have been published. Do you agree with that statement?
I agree with it, and I found that paper to be a very useful source of unbiased information.
And would you say that article is a preliminary data set for characterization of produced water in the Permian Basin, but not a definitive study?
Yes.
And why is that?
The reasons that Dr. Hughes stated. It's a restricted sample size. They didn't. They need to concentrate on non-targeted analysis. And then the other reason it was offered in NMED's direct testimony. They have to know the additives.
Thank you. That's all I have.
Thank you, Ms. Fox. Mr. Knight?
Good afternoon.
Good afternoon.
Let's see. Your proposed 20.6.8.400 A2, and if you could bring up the NEE's proposed rule language. So referring on page 3 to your proposed 20.6.8.400 A2.
Yes.
You proposed that it specifies that groundwater discharge permits are to be denied. Why do you not include surface water in there as the department did in its rule? Why? It seems like surface water discharge permits were specifically removed from your proposed rule, yet groundwater discharge permits were left in, and I just wanted to know why that was.
Madam Hearing Officer, Mr. McKnight, A lists 4 general requirements, and they all relate to no discharge. So number 1 is a general statement. Number 2 applies to groundwater. Number 3 applies to certification of a possible future EPA discharge permit allowing NVDS permit allowing discharge. I think the ground is thoroughly covered in for our 400A.
And you don't think that surface water should be specifically called out there?
It could be, but here's what it says. On number 3, the department shall deny certification of any federal permit proposing to discharge, dispose of, or reuse for activities unrelated to oil and gas. In number 1, it says, no person shall discharge, dispose of, or use treated water for activities unrelated to the production of oil and gas. And then number 4 deals with research, and it needs to be handled carefully without discharge. I don't object to surface water explicitly in here. I think the language covers it as is.
And so is it your position that your intent was that A3 covers discharges of surface water? Discharges to surface water, I'm sorry.
Yes, and it would not, I guess, apply to the point in the future when the NMED may have that delegated authority from the EPA.
No, that's where I was going. Thank you. Also, your proposed rule removes the language to restrict produced water direct and indirect discharge to both surface and groundwater. Why was that removed?
I think that's a totally valid requirement, but I think it was superseded by what we wrote in 400A. Certainly the same intent.
Okay, thank you. Did your proposed rule did your proposed rule undergo consideration by an advisory committee as the department's rule did?
No, Mr. McKnight, but neither did the department's amended rule.
And has your proposed rule undergone any sort of public comment process?
Mr. McKnight,
no.
NME offers this rule for the Water Quality Control Commission's consideration. It has not been through any process.
Thank you. You mentioned that NMED, or your testimony, I believe at one point said that NMED's proposed rule allows for discharges of produced water. Is that still your testimony, or did you misspeak?
No, it is my testimony, because prohibition of discharge is not enough.
Could you elaborate?
Certainly, Mr. McKnight. Discharges of produced water, spills rather, are illegal now on the oil field. They were made illegal by a rule after we failed to get a law passed that would have made them illegal in 2021. So they're now illegal by rule. There were 680, I don't remember the exact numbers. There are multiple spills a day, and there's no penalty to pay. So that is an example of why prohibiting discharge doesn't mean no discharge.
All right, so you agree with me that the rule proposed by NMED is a no discharge rule.
That's what it says.
And your proposed rule, where you talk about a produced water research permit, in the language of your rule, there's no provision for public notice or public comment on these produced water research permits, is there?
There is nothing on those, because we didn't think through the process of the whole permit application and approval process. It's my professional opinion that, given Mr. Brankert's statement, that they rely on agencies to bring them rules, or others to bring them rules, that such a rule needs to be prepared by the Environment Department as basically the staff of the commission.
But if the commission couldn't really adopt your rule as you're proposing it now, is that your testimony?
The commission could adopt the rule as I'm proposing it right now, and the NMED would have to come forward with a permit form that would be approved. And I'm not going to speculate what you would put into the permit or what that process would be.
You testified that the Clean Water Act, you testified earlier in your testimony that the Clean Water Act does not contemplate produced water. Do you recall that testimony?
I quoted a Texas Tech professor of law.
Are you familiar with Clean Water Act at 40 CFR Part 435, subcategory E, which allows reuse outside the oil and gas industry for agricultural use or wildlife propagation west of the 98th meridian.
I'm aware of that exception, yes.
Are you familiar with Clean Water Act Part 437, which discusses produced water treated at a centralized waste system?
I am, and I understand the background for that.
And are you familiar or are you aware of Clean Water Act oil and gas effluent limit guidelines specific to oil and gas?
There was an echo there. I could not understand you.
I said, are you aware of Clean Water Act oil and gas effluent limit guidelines specific to oil and gas?
What kind of effluent guidelines?
They are oil and gas effluent limit.
Effluent limit.
Are you familiar with those?
No.
Okay. You described industrial projects as defined in NMED's proposed rule as a type of reuse. Yet the definition of that term specifically states that these projects are non-discharging. How does that square with industrial project as a type of reuse?
Again, Mr. McKnight, produced water is novel and it is incredibly toxic beyond the large volume waste that anybody in New Mexico or the Western United States has handled. And we're talking specifically, I think, here about Permian Basin produced water, which is very different than produced waters elsewhere. We've heard testimony to that effect. We know that California allows produced water reuse from conventional wells, but has banned it from fracked wells. I know the Produced Water Research Consortium determined that the type of well is the most important distinguishing characteristic about the produced water that comes out of that well. And this situation with reuse by industry without a permit as a water supply in a closed loop system without discharge, well, it doesn't meet my engineering definition of a closed loop system. It doesn't meet, the English definition of closed loop because it can't be. I mean, it literally cannot be. There are residuals that have to be gotten rid of. And as we have already discussed, you and I, banning discharge does not mean there will be no discharge. And the discharge could occur in all of the places. But that 7664P says the Environment Department needs, the Water Quality Control Commission must regulate.
But a discharge is not the same as a reuse. Would you agree with me there?
Discharge is not the same as reuse. I agree. Okay. But reuse with a no discharge permit does not mean that discharges will not occur.
Understood. I'm going to, if I could, I'm just going to read a sentence from the Water Quality Act and then from the Produced Water Act, and then I have a question following that. I'm reading the Water Quality Act 7465A. It says, by regulation, the commission may require persons to obtain from a constituent agency designated by the commission a permit for the discharge of any water contaminant or for the disposal or reuse of septic or sludge. All right, you're probably familiar with that provision in the New Mexico Water Quality Act. And then the Produced Water Act at, let's see, 7013-4D says, for uses regulated by the Water Quality Control Commission, a person shall obtain a permit from the department of environment using the produced water, the recycled or treated water or treated product or any byproduct of the produced water. So I guess my question on that, if there is no if there is no authorized discharge, under what authority could the department issue produced water research permit that your rule contemplates?
The Water Quality Act can be read narrowly or it can be read more broadly, and the recent additions that are specific to produced water of this novel waste need a very well-considered approach to assure that the people and the environment are not harmed. A no discharge, I believe that if the department has the authority to issue a discharge permit with limitations, it has the authority to deny discharge at all if there's no science that says what's in the waste.
But I guess my question was, under what authority could we issue this, under what statutory?
Well, there's a statute, and I cited to you. There is a Water Quality Act provision that, let me see if I can find it in my testimony. I testified to that. And I'm not sure where it is. I believe that authority, Mr. McKnight, is in 7464E. Shall adopt regulations to be administered by the Department of the Environment for the discharge, handling, transport, storage, recycling, or treatment for the disposition of treated produced water, including various types of applications. If you have the authority to permit these things, to regulate it, you have the authority to say, no, you haven't met the bar, to show us that there will be no spills. Storage, recycling, or pilot research, if you will, treatment for the disposition of treated produced water. You have the authority to permit it. You have the authority to deny it.
Let's see. Just a couple more. When in your testimony you were talking about standards for research, is there a reference, or do you have a reference of what those standards are or what they would be? And do the standards vary based on the research goal of a study? Would one standard be applicable to all research, or how do you envision that?
Thank you for that question, Mr. McKnight. I am not a scientist. I'm an engineering scientist, and I don't do research. But science is understood to be a process of peer review, peer-reviewed publications with complete information so that science can be replicated by others. That becomes science. And we need a science foundation that is accepted by the Water Quality Control Commission as the basis of standards. Standards are the basis of regulations, and then you can get to the permits for use as provided in the Produced Water Act and the Water Quality Act.
And finally, in your proposed rule, NEE's proposed rule, you talk about the department making a determination of whether the benefit outweighs the risk when granting a produced water research permit. How would NMED go about, in your opinion, how would we go about determining whether the benefits of any particular produced water research project outweighs the risk?
Well, as an example, if a proponent came forward and said they wanted to they wanted to do a pilot test of a treatment train to do, some specific goal, but they weren't measuring. They didn't propose in their research plan to measure the contaminants, the pollutants of interest to the NMED. Then NMED should not allow that research because the risk and spills and everything doesn't outweigh the gain. That would be the case for many of the pilot projects that I have looked at what's available in the record. And I mean, the data aren't there. The measurements aren't there. What did they measure? Well, they measured conventional pollutants. What was the removal process for TDS? Not TDS, for PFAS and other things.
All right, as a general statement, but would you agree with me that there are no specific criteria in your proposed rule for how we would go about evaluating whether the benefit outweighs the risk for any particular research project?
We didn't propose such criteria. The Environment Department is the regulator. Not the regulator, is the enforcer of the regulations, is the proposer of things. And the department has a professional staff to think this through and come up with something where science is done, the science is beneficial, and the benefits outweigh the risk. And again, pilot plants or the pilot projects under the consortium that have been reported on, there's sparse information about them, but they were woefully incomplete. I didn't even see research objectives. And you heard that the Environment Department the Produced Water Research Consortium doesn't even know when some of the reports they didn't even know if a report is finalized. So there has to be guidelines, more than guidelines, permit requirements that research needs to be conducted according to the standards of science as a discipline.
But finally, you agree with me that those standards are not in the language of your proposed rule?
They are not.
Okay. That's all the questions I have.
All right, thank you, Mr. Knight. Ms. Nanasi, are you going to have any redirect?
I do have a couple of questions.
Okay, we need a break. Okay. So let's take 15 minutes to 4:30. Righty, we are back after a short break, and Ms. Nanasi indicated that she has some redirect questions of Mr. Gom.
So we're back on the record, and for the record, my name is Mariel Nanasi. I wanted to follow up on Mr. Maxwell's questions about how do you know about all the spills, and I refer you to Norm Gom Exhibit 19 as part of your rebuttal. What is this exhibit?
It's a Bureau of Land Management report on produced water handling in New Mexico.
And could you please specifically go to page 10? And there's a table there, is there not?
Table 2.4, summary of 2022 spills in the state of New Mexico.
And could you please, sir, look at the line that refers specifically to produced water, and what does it say? How much, what was the volume of produced water that was released?
There were 658 spills that released a self-reported total of 105,251 barrels, resulting in the loss of 68,306 barrels.
And how many gallons are there in a barrel?
42.
Now, I wanted to ask you about Mr. Knight's question about surface water. Would you be amenable to including that in new energy? Would you be amenable? Is that where you at? Would you be amenable to adding the word surface water to, and then also the same thing goes for both direct and indirect use? Would you be amenable to including those two suggestions by NMED?
Certainly.
Now I'm asking you, sir, you were asked questions about discharge. Did you hear NMED's testimony that said that with demonstration and industrial projects pursuant to a notice of intent, that there would be discharges even with a closed loop system?
I did hear NMED technical witnesses testify to that point.
And could you pull up your rebuttal on page 2 and line 10? Would you read that? And I think it's a quote from an NMED witness. And would you tell us who that is the site is to? Here's your rebuttal testimony. And if you could go to page 2, line 10, and if you could read that for the record.
NMED also admitted that the notice of intent process will authorize closed loop projects that are, quote, not necessarily non-discharge. This is unacceptable because Permian Basin produced water contains a plethora of known and unknown contaminants and pollutants, of known and unknown toxicity, including enormous amounts of salt, volatile and semi-volatile organic compounds, petroleum hydrocarbons, organic acids and oils, naturally occurring radioactive material, other inorganic constituents, for example, sulfide and ammonia, and chemical fracking additives, which are very dangerous to human health and the environment.
Sir, when you were quoting from NMED is saying that there would be discharge from the demonstration and industrial projects, could you specifically state which NMED witness that is a quote from?
That is a quotation from Ms. Plum at line 77 in her direct testimony. Sorry, her rebuttal testimony. No, direct.
Now, Mr. Wexler asked you, I think it was the last question, about would the rule that we're proposing forbid or prohibit demonstration or industrial projects. Could you explain
why that is so.
Industrial scale projects and demonstration projects. Well, first of all, industrial projects are not constrained by anything in the definition. They could be so many different things. Could be located anywhere. Could be huge, could be small. We just don't know. Demonstration projects, that term was used in the original NMED rule to only refer to pilot tests and bench scale tests. It's not a demonstration project. The rules should be understandable. You should be able to take words like demonstration at its English meaning. So our rule substitutes pilot projects and bench scale projects for the department's term demonstration projects that includes both of this, because all they do is produce science. They produce, I'm on a pilot plant, you have an effluent that you can assess for toxicity. Industrial projects and a demonstration project, or rather a pilot scale project as the rule provides that we're full scale, as we've talked about, is a whole different animal altogether.
I'd like you to look at the rule that we proposed, and here's the rule. If you could tell the commissioners what are the requirements, what are the guidelines that our proposed rule requires.
Subsection D of section 400 contains this language, and I think it's best that I just read it. Any person desiring to conduct a bench scale project or pilot project using produced water shall submit a produced water research permit application to the department. That's 1. 2, a produced water research permit application for a bench scale project or a pilot project shall A, include a plan and objectives, B, disclose all chemical constituents within the produced water, C, explain treated produced water quality, treatment volumes, and toxicity studies, D, set forth the written procedures that will be followed to prevent releases onto the ground directly or indirectly into ground or surface water, and E, identify any and all risks proposed by the proposed handling, storage, transportation, and use of produced water and all procedures that will be followed to minimize such risks. 3, the department shall evaluate produced water research permit applications and shall only grant a permit if it determines that the benefits of the proposed research outweigh the risks proposed to health, safety, and consider the volume of produced water involved in the proposed research, the locations of the proposed handling, storage, transportation, and use of produced water, the proposed activities involved in the research, the character and history of the applicant, and any prior regulatory non-compliance by the applicant. 4, any produced water research permit issued pursuant to this section shall require the applicant to A, maintain a repository of all scientific data generated during the research, B, submit to the department all research results within 90 days of completion, C, permit the department to inspect the project upon request, E, permit the department to review all scientific data generated during the research upon request, E, dispose of produced water and any materials that come into contact with untreated produced water or treated produced water, including soils, plant material, treatment equipment, and containment area materials in accordance with the provisions of the Oil and Gas Act, NMSA 1978, Section 70-2-12, and pursuant to the Oil Conservation Commission's regulation. F, construct the research project in such a manner as to ensure that no discharges of produced water occur throughout the entire duration of the project, and allow the department to inspect and verify that the project is not resulting in the discharge of produced water. G, require that all untreated and treated produced water shall be handled, transported, stored, used, and disposed of in accordance with all other applicable local, state, and federal regulations. 5, any permit issued pursuant to the subsection shall be subject to revocation if the applicant fails to comply with the requirements of the permit. 6, persons intending to conduct a bench scale project or pilot project shall satisfy the department financial assurance requirements to ensure that any damages caused by the applicant are remediated.
So, Mr. Gom, there are standards in New Energy Economy's proposed rule that an application could be based on, just like the NMED's rules, which has standards set forth in their notice of intent without a permit process, but they were, and there's no application attached to their rule.
That's correct.
And these permits would be required for bench scale and pilot project. Is that correct?
That is correct. It's imperative that research continue. It needs to be enabled and regulated so that the benefits outweigh the risks.
So what I understand your testimony to have been is, number one, there's a requirement that a permit is required for all use outside the oil field, and two, that science, that the bench scale project and pilot project be based on science.
Absolutely.
There's a difference between academic research and pilot projects, are there not?
A very big difference.
And you understand the academic research that is part of this record in this case says we need more science, right?
Yes.
But the pilot projects have produced no data that can be relied on. Is that also true?
The pilot projects to date have produced no data that meets any scientific standard, any standard of science.
I think this is my last question. You heard Mr. Hightower testify in May that their last April 2024 Dr. Peju's research not only found new compounds, but because of the heating of the compounds that they knew, that new compounds were discovered that had not previously ever been noticed. Is that right?
That's right. And Mr. Hightower was forthcoming about that.
Nothing further. Thank you.
Okay, thank you, Ms. Anasi. Mr. Knight.
Madam Hearing Officer, I just have one question relevant to the testimony we just heard. At the very beginning, I believe you cited to some of Ms. Fulham's testimony with a page and line number. Could you clarify that for the record and just so we can find the testimony? We were unable to find it based on the citation.
It was not direct testimony. It was from her transcript at 77. Water Quality Control Commission 23-84, transcript, May 16th, 2024, Fulham at 77. 77.
Is that a page number?
Yes, but I don't know how to get it from here.
It would be helpful if we had a page number so that we could.
For the record, it was WQCC transcript of May 16th, a Q&A that Ms. Fulham answered at page 77.
Okay, page 77 of the transcript.
Yes.
Okay, thank you.
Any reason not to excuse Mr. Gom at this point? Reason not to excuse Mr. Gom? No? Fine. Thank you very much, Mr. Gom.
Thank you, Madam Hearing Officer, Chairman Bruce Thompson, and members of the commission.
Madam Hearing Examiner, now I would like to move the other exhibits that you said that you were going to hold off on ruling on, or should I week further?
No, this is great.
Okay, so that is Exhibit 1, Exhibit 4, Exhibit 18, I think you already admitted, but
Right.
the other two are Exhibit 3 and 13.
3 and 13. And what about 21? I had a note that at one point Mr. Gom referred to 21.
That's included in New Energy Economy Exhibit 18.
Okay, thank you. 3 and 13. Are there objections to 3 and 13? Not hearing any objections. Any E3 and 13 are admitted.
Thank you.
So I understand, Ms. Nanasi, that we'll hear from Mr. Noble first thing in the morning.
At 10 o'clock, correct?
Oh, at 10. So,
Because you said that public comment would be from
oh,
9 to 10.
sorry. Yeah, I never know exactly how many public commenters
so
there will be.
He will be here after public comment.
As soon as public comment
Yes,
is
thank
over.
you.
All right. And then, but we don't have Dr. Van Glosch tomorrow.
Correct.
That will be Wednesday. So, as I understand it, we don't know when Ms. Troutman will be available. So at that point, the last set of witnesses are yours, Mr. Wexler. Would you address witness availability now, knowing any ease witness availability?
I think that our witnesses will be prepared starting tomorrow. So the order will be tomorrow should be Missy Courier for short non-technical testimony, followed by John D'Antonio and his technical testimony. After that, I believe it's yeah, I think it might be Mr. McCurdy, but allow me to check in with them. I believe they're all available for the remainder of the week with a couple of polls that we'll work around.
Okay, but we'll start with Courier and D'Antonio.
Correct.
And then move to either Balch or McCurdy.
That's right.
Okay.
That's correct. Courier followed by D'Antonio, and then one of those other witnesses, if necessary.
Okay. All right, thank you, Ms. Nanasi. Great. So at this moment, it is.
I'm sorry, may I apologize for
Yeah.
interrupting. Ms. Olson was reminding me that Mr. Jacoby will actually be here to listen to Mr. Noble's testimony. And so after Mr. D'Antonio will do Jacoby because he's already going to be here rather than have him come back.
Sure. I'm sorry. So I understand. We'll do public comment. We'll hear from Mr. Noble.
Correct. Then Ms. Courier,
Yes.
Mr. D'Antonio,
Yes.
and then Mr. Jacoby, because he will be here already listening to Mr. Noble.
Say the name again.
Jacoby,
Jacoby. Thank
Correct.
you. We're beginning to echo here, and I was having.
Sorry, that might have been getting too close to another microphone.
All right. Thank you very much. Okay, so at this point, let's turn to public comment. And let me just say, we will not be doing any more of the technical case today. We're going to take as much public comment as there is, and then we'll be adjourned for the day. I don't know that we'll get all the way to 5:30 since I only have half a dozen or so names, but we will not be going back to the technical case regardless. On other days, we may go all the way to 5:30 or even scooch it a little later than that, but not today. So let me call the names that I have, and I will make an open invitation to anyone in the room who would like to offer comment. Savannah Woods in the room or on the platform? Okay. Noreen Kelly in the room or on the platform? Nope. Joey Smallwood. Okay. Seneca Johnson. Okay. Martha Burt. Martha Burt. Oh, terrific. Ms. Burt, would you spell your first and last name for the transcript, please? Thank you. And do you swear or affirm to tell the truth? Excuse me? Do you swear or affirm to tell the truth?
Of course.
All righty. I'm going to start your 3 minutes now.
Okay. Good afternoon, Chair, members of the Commission. My name is Martha Burt. I am the co-chair of Indivisible SOS Santa Fe, a group of about 100 women who are very active in public affairs and legislative action. You have heard extensive testimony from experts about the dangers that this rule would pose to the health and safety of all New Mexicans. I am not an expert, and I will not pretend to be one. What I want to urge you to do is to reject this rule out of hand. The rule is really no rule at all. It offers no enforceable guidance. It leaves our state vulnerable to untried and reckless experimentation with no effective control over what happens. I have a lot of experience with rulemaking from my 35 years as a policy researcher at the Urban Institute in Washington, D.C. That experience has taught me what a rule should look like. It should not look like this one. This rule leaves the Environment Department with no way to protect public health and safety, with no way to reject an application for anything at all that the oil and gas industry wants to try. It also violates the law. The law in question says that a rule governing produced water needs to have an enforceable scientific basis for making decisions about whether a specific proposed use of fracking waste is safe for the public and the environment. There are no such criteria in this rule. And the reason there are no such criteria in the rule is because those criteria do not exist. Science has been unable to establish such criteria because produced water is so full of such dangerous substances. Testing is expensive. Testing is not yet able to address many of the substances in produced water. And testing itself seems to create even more harmful substances, as you heard from the experts. We can't say anything is safe if we don't know what's in the stuff. The circumstances surrounding this rule further suggest that the commission reject it and send the department back to the drawing board. I refer to the complete inability of NMED to police existing restraints on the oil and gas industry. As you have also heard from experts, spills happen. They happen on average 4 times a day. Today, they happen within the control environment of the oil field, at least theoretically. If this rule is allowed to go forward, these spills will happen out where they will harm everyone. It is extremely likely that these spills violate the law's restrictions on contaminating existing water supplies. The department is, at a minimum, extremely lax about enforcing these rules. There is nothing in the department's current or past behavior to give anyone any confidence that the proposed rule will be any better enforced. And indeed, the proposed rule sets itself up as needing no enforcement because it allows the industry complete freedom to do its destructive best.
Will you wrap up?
The rule, is that 3 minutes?
Wrap up.
Okay, don't do it.
So you can just wrap up.
Oh. The rule is premature. The rule is an example of a public agency not doing its job. And one suspects that this rule is yet another example of the state of New Mexico allowing the oil and gas industry to run roughshod over the interests of the public.
Okay, thank you very much. Jackie or JC Hood? Jackie or JC Hood? No? Okay. Let me turn then to address those on, sorry. First, let me ask, is there anyone else in the room who would like to offer comment? I think I recognize everyone else. All right, there's no one else in the room. Let me now address the platform. Is there anyone at all who has not yet offered public comment, either in May or earlier today, who would like to offer public comment at this time? There will be other opportunities every day that we're in hearing. Oh, yes, Ms. Adler.
Yes.
Would you spell your first and last name for the transcript?
Sure. It's Laura, Lara. Last name is Adler, Adler.
Do you swear or affirm to tell the truth?
Yes.
Thank you. I'll start your 3 minutes now.
Okay. My notes just went away. Okay. Thank you for your time. For the past 13 years, I've been teaching medical and health professionals around the world about the effects of toxic chemicals on human health and their links to hundreds of chronic health conditions, cancer, birth defects, autoimmune disease, metabolic disease, infertility, and more. In the years I've been doing this work, I have seen countless instances.
Ms. Adler,
Yes.
I know you want to maximize your time, and I will give you a little extra time because I'm speaking at you. But the court reporter is trying to catch all of your words, so you need to slow down a little.
Okay, can do that. In the years I've been doing this work, I have seen countless incidences where industries in pursuit of profit or cost savings have endangered the lives of millions of people by either not considering or outright ignoring the potential and actual downstream consequences of the chemistry they use. This is typically followed by the discovery, years later, of toxic chemicals in our air, soil, water, food, etc. Chemicals that we end up spending decades and billions of taxpayer dollars attempting to address and remediate. Many toxic chemicals, including ones found in produced water, are highly persistent, and once introduced into the environment are all but impossible to remove, like DDT from the 1970s that is still found in soil, food, and therefore people. We are still dealing with the consequences of leaded gasoline 103 years after it was introduced. When we put profits in front of people, this is the pattern that we see over and over again. Produced water contains hundreds of highly toxic chemicals, most of which are unregulated under the Safe Drinking Water Act. For many of these chemicals, there is no safe level of exposure. This means that even the tiniest amount that may intentionally or unintentionally make its way into groundwater sources can be toxic with devastating health consequences. This includes chemicals and metals like arsenic, barium, bromide, mercury, benzene, toluene, ethylbenzene, and xylenes, all highly toxic. as well as PFAS, which are present in produced water. PFAS chemicals are the DDT of our time. Their toxicity is now well established and to date have been linked to high cholesterol, testicular and kidney cancer, liver damage, thyroid disease, decreased vaccine response, asthma, fertility problems, and more. That they are actively being used in New Mexico oil and gas extraction is not only wildly irresponsible, it's also going to be costly to address. We cannot kick the can of PFAS pollution down to our children, grandchildren, and great-grandchildren. The gas and automobile industry knew that tetraethyl lead was toxic the day they added it to gasoline. DuPont, the makers of PFAS, not only knew of the toxicity of their product, but hid this information from the public for decades, which is why we cannot leave it up to the oil and gas industry to define what is appropriate treatment for produced water. And we cannot leave them to police themselves when it comes to proper handling of this highly toxic waste. I'll close by saying that New Mexico water is already under serious threat thanks to the SCOTUS ruling on Sackett versus EPA. Currently, 90% of waterways in New Mexico are no longer considered waters of the United States and are therefore not protected under the Clean Water Act. At a time when protections have been stripped from New Mexico waters, we do not need the gas and oil industry messing around with profoundly toxic wastewater. Thank you for your time.
Thank you, Ms. Adler. Is there anyone else on the platform who would like to offer public comment at this time? Anyone else at all who hasn't already offered comment? There will be other opportunities. The next one is at 9 o'clock tomorrow morning. Another one at 1 o'clock tomorrow afternoon. Going once? No? Okay. Terrific. We will adjourn then for the day and resume this hearing at 9 o'clock in the morning.